Awesome. It worked.
Okay. I'm going to let the judges in and
Okay.
then we'll get going.
All right, great. Thank you so much. I really appreciate it. Best of luck today.
Thanks.
All right.
How do I, while I got you here, I adjust the view?
Awesome. It worked.
Okay. I'm going to let the judges in.
Okay.
And we'll get going.
All right, great. Thank you so much. I really appreciate it. Best of luck today.
Thanks.
What coffee flavor did you put in mine yesterday?
I have someone in there.
Which coffee flavor did you put
I
in?
think just the regular one.
Which one?
I don't know. The live blue.
Okay, come on, guys. Come on. Come on, come on.
Good morning, Colette. Can you hear me?
Hi, good morning. How are you?
I'm doing well. I see you are one of the co-scoring judges for this round.
Yep, I'll be a scoring juror this round.
Have you scored this before?
Yes, last night actually.
Okay, looks like you already know the deal, keeping you on a black screen there.
Yep, exactly.
I'm not seeing the other judge, so we'll hang out for just a second before I let the competitors in. I'm gonna go do a last minute coffee run. I will be right back.
Sounds like a good idea.
Good morning, everyone. We'll get started here in a second.
Your Honor,
Yes, sir.
before we begin, I just want to bring to the court's attention, there was a last-minute email clarification regarding the time of today's trial. And because of that last-minute change, our witness playing Karen Bajia, she has a family obligation right now, so she'll be joining us in the latter half of today's trial.
Yeah, no worries. I'm guessing, is she a defense witness?
Yes, she's playing the defendant today, Karen Bajia.
Okay, no worries. I think we'll get to her here in a bit. I think we're missing a scoring judge. Everybody sit tight for a few minutes. We are waiting on the last scoring judge. They might have to substitute someone in. So we'll begin here in a few minutes. Thank you. I think we just had our final scoring juror begin or enter the courtroom, so I think we're getting ready to go. First, from the parties, plaintiff starts. Do we have anyone that we're missing? Aside from that one witness I know the defense mentioned, is everyone who needs to be in the courtroom here?
Yes, for the plaintiff, everyone's here.
And from the defense?
Everyone but that one witness I mentioned earlier, Your Honor.
Okay, so we'll go ahead and get started. Obviously, we are here for the fourth round of this year's Summit Cup tournament. Will the attorneys please enter their appearance, starting with plaintiffs, please?
Yes, Your Honor. Your Honor, my name is Jasmine Mattier, JasmineMattear, and this is my co-counsel.
Hello, Your Honor. My name is Magner Tiuso. First name is spelled Magner, last name Tiuso.
And together we have the pleasure of representing the plaintiff, Cam Donaldson, in this matter as Team Kit Carson.
Good morning. And from the defense?
Good morning, Your Honor. My name is John Hobbs, representing Ms. Karen Basia today.
Good morning, Your Honor. Matthew Nunez, representing Ms. Baja as well. She'll be sitting at counsel's table.
Before we go into any preliminary issues, I want to ask the scoring judges, do you know anyone on either team to a degree that will affect your ability to provide an unbiased evaluation? So essentially a conflicts check. Feel free to chime in orally or if you want to put something in the chat.
do
I
not
don't
have
know
any
anyone, Your Honor.
conflicts.
Okay, sounds like neither scoring judge has a conflict. Is the plaintiff side ready to proceed in this case?
Your Honor, prior to proceeding, we have a few preliminary matters as well as motions in limine to be heard outside of the presence of the jury constructively.
Sure, and let's make sure, is the defense ready to proceed as well?
Yes, Your Honor.
Before we get into those pretrial matters, if I could have the parties raise your right hands for the swearing in process. Attorneys, please indicate by saying "I do" if you swear to abide by the rule of this proceeding and conduct yourself in a manner that is honorable to the forum.
I do.
I do.
Thank you. We are now calling the case of 082263 Cam Donaldson versus Karen Baja. It sounds like the plaintiff side has some housekeeping matters. You can go and continue with those now.
Yes, Your Honor. Your Honor, it is our understanding that the federal rules of evidence as well as the federal rules of civil procedure preside in today's case.
That is my understanding as well.
And Your Honor, we expect that both parties will make objections throughout the entirety of this trial. We ask that we say "may I approach," but do so constructively so that the jury can benefit from hearing our arguments.
Of course, I think that's our only option in this forum.
Yes, Your Honor. And finally, Your Honor, what is your preference on tendering witnesses as experts? Would you like us to lay the foundation and then formally tender them, or just lay the foundation and go into their expert opinion?
I'd like you to lay the foundation and then formally tender them so that the defense can challenge the scope of the tender. And then if they have any particular voir dire, I would allow that as well.
Yes, Your Honor. And Your Honor, with that, we are ready to proceed with the motions of limine.
Does the defense have any preliminary matters before we get to motions in limine?
Yes, Your Honor. Our first preliminary matter deals with the technology being used today because of the format of Zoom. Would Your Honor prefer that when advocates aren't presenting a statement, directing or crossing witness, that they turn their videos off?
I think that's the preference, and you guys are going to have to bear with me here in terms of the technology. Is there an agreement between the parties or a preference as to how it should be normally set throughout directs and crosses?
Whatever the court prefers. I'm sorry, go ahead.
Yeah, I was going to say there's no disagreement. We're fine with turning the video off when we're not the advocate in the situation.
Yes, same with the defense, Your Honor.
I'm going to go ahead and try and hide the non-participants and keep it in a gallery view. So I'm going to hide the scoring judges. Is that better for everyone?
Yes, Your Honor.
Yes, Your Honor.
Okay. Does the defense have any other preliminary issues?
Yes, Your Honor. Again, because of the technology we're using today, we want to bring to the Honor's attention that my co-counsel and I will be using a 2-camera setup. So if you notice we're taking a moment to go from one camera to another, it's for that reason.
Okay.
Lastly, we're again, since we can't confer in person, we'll be using a private chat function to confer with co-counsel.
Okay. Is that agreeable to both parties?
Yes, Your Honor.
Any other preliminary matters from the defense?
Nothing else from the defense, Your Honor.
Does the plaintiff have any motion to eliminate?
Yes, Your Honor, we have one motion to eliminate as well as one stipulation. Which would Your Honor like to hear first?
Let's hear the stipulation.
Your Honor, both parties have stipulated to a document that we have formed. Your Honor, during our expert witnesses testimony, we are going to be doing a handwriting analysis, and we have extracted the signatures from different documents just for the ease of presentation and placed them onto one document. We haven't altered the signatures. We've just placed them in one document just for the ease of presentation, and both parties have stipulated to that document.
Is that true? The defense stipulates to a summation document through the expert?
Yes, Your Honor.
And with that, Your Honor, we're ready to proceed to our MIL.
Let's hear the contested motion to eliminate.
Your Honor, the plaintiff moves to exclude any and all hearsay testimony that the defense will try to enter through their witness, Chris Renard. Your Honor, if Mr. Renard testifies consistent with his report, he will testify as a fact witness as to what other people told him for the purpose of proving the truth of those statements. That most or all of that testimony is inadmissible pursuant to Federal Rule of Evidence 801 as hearsay.
Any response from the defense?
Yes, Your Honor. Defense will not elicit any testimony with regards to what the police department said. So we will agree with that motion.
At this point, I'm going to reserve a ruling. I think it's hard for me to make a determination as to what is and what is not hearsay without hearing some sort of witness testify. I think there are plenty, obviously, exceptions to hearsay. I think when it comes to one police officer talking to another, it could just be the effect on the listener and may not be offered for the truth. So I think for this particular motion, it's a trial issue, and I will reserve ruling.
Yes, Your Honor. With that, I apologize.
Does the plaintiff have any other motion to eliminate?
No, Your Honor.
Any
Your
from
Honor.
the defense?
Yes, Your Honor, but a quick clarification with regards to that last ruling. Would you like me to make the court aware when the questioning is getting to that moment?
I'm going to leave that to the plaintiff. If they have a particular objection, they can lodge it at that time.
Yes, Your Honor. That, for our motion, by way of background, this is a case in which the plaintiff is bringing a wrongful death suit against my client, Karen Baja, for the disappearance of her husband. Ms. Baja denies these claims. Now, the defense anticipates that the plaintiff will offer a video of a man named Exotic Bob and a later transcription of that video. As an offer of proof, in that video, Exotic Bob sings a song presumably about my client in which he claims to have killed her husband. Second, he specifically states that Ms. Baja told him that while they were doing a highly illegal deal, Ms. Baja said, and I quote, let me just pull it up. Exotic Bob, I swear if you double cross me on this deal, I will do to you exactly as I did my husband. There won't be no disappearance, no mythical flight to Costa Rica. Your last supper will be you. In this statement, Exotic Bob was not under oath, nor was he subject to cross-examination. Defense moves to preclude any evidence of this video or its later transcription due to 2 levels of hearsay. Additionally, the dangers of unfair prejudice to Ms. Baja substantially outweigh any probative value that the video or the later transcription may have. Would Your Honor like for me to discuss the hearsay issues further?
Yes, please.
So, Your Honor, there's 2 levels of hearsay. First, it's Ms. Baja's words to Exotic Bob. And while we understand that this alleged statement is remedied by party opponent, Exotic Bob repeating these words in his statement is hearsay for which there is no exception.
Does the plaintiff have any response?
Yes, Your Honor. Your Honor, we'd like to call court and counsel's attention to stipulation 4, where we are allowed to bring in a transcript of this. Your Honor, opposing counsel has mentioned that they anticipate we will show the video. Your Honor, we have no intention of showing the video. We will just simply be reading a part of the transcript, which opposing counsel has read. Your Honor, in response to the hearsay arguments, the statements from the defendant is remedied by party opponent. And any statement from Exotic Bob in this paragraph is a statement against interest. This is an unavailable witness. Your Honor, this has been stipulated to by local rules that this witness will not be able to testify today. And therefore, he is unavailable. And the exception to hearsay is that this is a statement against interest as he is talking about an illegal deal. And this subjects him to civil and criminal liability.
Final word to the defense.
Yes, Your Honor. His statement must expose him to criminal liability. However, plaintiff's counsel has failed to prove to you or show that it was more likely than not that the crime that Exotic Bob is currently in prison for is not this crime that he mentions in the statement. And additionally, anything that Karen Baja told Exotic Bob about any alleged crime she committed have nothing to do with his exposure to criminality, to criminal liability or interest.
Can I respond, Your Honor?
Sure.
Your Honor, in response to the relevance of these statements, as opposing counsel stated, a material fact at issue that we have in today's case is whether or not the defendant killed Mr. Donaldson. These statements are more probative than they are prejudicial, as it tends to show how Karen Baja, the defendant, stated that what she did to Mr. Donaldson. She stated that she fed him to the cats. She stated that there is no mythical flight to Costa Rica. All of these are alibis that the defense will try to present to the jury. Therefore, any probative value that this testimony has is not substantially outweighed by any prejudice that opposing counsel has mentioned.
I think at this point, I'm going to allow the statements to come in. It sounds like this particular video is stipulated as admissible. Obviously, the defense is free to raise any additional objections they have if other portions are brought in. But siding with the plaintiff, I think that these are statements against interest and statements of a party opponent. Again, feel free to re-raise any other objections to portions of the video if they bring them in through testimony.
Yes, Your Honor.
Any other motion in limine from the defense?
That's all for the defense, Your Honor.
At this point, I think we're ready to proceed to opening statements. I want to verify before we do so, do both sides have someone taking time for them?
Yes, Your Honor. It should be the witnesses, the host witnesses.
Okay, great. Opening statements from the plaintiff.
Point of inquiry, Your Honor.
Yes.
Your Honor, if I understand correctly, it is opposing counsel's host witness isn't here yet, so I don't know who will be taking the time for them.
Is that something the defense can figure out?
Your Honor, our host witness is here. The witness playing Karen Baja will be joining us later on.
Yeah, I'm recording. I'm recording the time.
Okay, great. Thank you, guys.
I apologize for that misunderstanding.
That's okay.
Ready to proceed to opening, Your Honor.
You may begin when ready.
Will you please the court? Counsel, members of the jury. The first law of nature is self-preservation. In nature, you're forced to rely on your instinct, to be the predator or the prey. Today, you're going to learn that the defendant, Karen Baja, decided to follow only one law, the law of self-preservation. You'll learn that the defendant only decided to look out for one person, herself. Now, in order to understand how all of this applies to today's case, we need to go back to the early years of this defendant's life. You see, it's at this point in time that the defendant, well, she hasn't had much luck with life. She isn't born into a wealthy family. She doesn't have much to her name. But suddenly, one night, everything changes. She meets millionaire Lou Donaldson. And at first, it's like a dream. Her and Mr. Donaldson, well, they begin to date. And soon after that, they end up getting married. And Mr. Donaldson, he offers the defendant an opportunity to help run his family business called Wild Wild Life, which is a big animal sanctuary, together with him and his daughter, Karen Donaldson. You see, in the defendant's mind, she thinks that Mr. Donaldson is her Prince Charming. She gets to leave her old life behind and spend the rest of her days in a castle. But members of the jury, what was once a dream for this defendant, well, you'll learn it soon became a nightmare for Mr. Donaldson. If you fast forward to June 2012, you'll learn that one thing changes, but one thing stays the same. You'll learn that at this point in time, Mr. Donaldson, he now wants a divorce. But the defendant, well, she still wants everything. And it's important to keep this event in mind because this event is what turned the defendant's life upside down. It's at this moment that the defendant realizes that she's been kicked out of her castle. It's at this point in time that she realizes she needs to look out for herself. And that's exactly what she does. After Mr. Donaldson mentions a divorce, well, the defendant begins to threaten him. And so Mr. Donaldson, well, he does what any reasonable person would do. He attempts to get a restraining order. Members of the jury, a few months after these events occurred, Mr. Donaldson goes missing. 5 years have now passed, and no one, not a single person, has seen or heard from Mr. Donaldson. Why? Because you'll learn that this defendant killed him. She killed him thinking that this was the best way to look out for herself. Members of the jury, you're going to learn that in this jurisdiction, you need to wait 5 years in order to have someone legally declared dead. And today you'll hear how this defendant, just one day after the 5th year anniversary of Mr. Donaldson's disappearance, rushed to the courthouse and had him legally declared dead. And then she was $5 million richer. Now, members of the jury, you don't have to take my word for any of this. No, we're bringing to you 2 witnesses today. These are people who are currently living through this nightmare. We're going to bring to you Cam Donaldson, and that's Mr. Donaldson's daughter. And she'll tell you about the last few months of her father's life, about the divorce, about the threats, but pay particularly close attention to when she begins to talk about the last time she ever sees her father. She'll tell you how she's locking up from work, and when she turns around, she sees her father, and they begin to talk. And they begin to make dinner plans for that weekend. And as that conversation draws to an end, well, she looks at her dad and says, "Bye, Dad. I'll see you at supper." Members of the jury, that supper never happened. A couple days after that, an alarm goes off at Wild Wild Life. So Cam Donaldson, she hurriedly gets ready and she heads to Wild Wild Life. She's thinking to herself, what went wrong? Did a tiger escape? Is there an intruder? And so she heads straight to her office. And outside her office, she finds a man with bolt cutters. And next to that man is the defendant. And in the defendant's arms, she has a lockbox. And you'll learn that inside that lockbox is the last will and testament of Mr. Donaldson. A few days after that, the defendant, she's left in charge of Wild Wild Life. But Miss Donaldson, Mr. Donaldson's daughter, she's fired. Why? Because the defendant was looking out for number 1, herself. We're also bringing to you an expert in handwriting analysis and investigation. That's Mr. Pride. Now, Mr. Pride, he's going to sit before you today, and he'll explain to you all the mysterious facts surrounding Mr. Donaldson's disappearance. He'll explain to you about the divorce, about the threats, and pay close attention to when he begins to talk about an alleged will that the defendant claims Mr. Donaldson signed just 2 days after he filed for a restraining order. Members of the jury, you're going to be walked through a step-by-step analysis on that will and the signature in that will. And you're going to come to the same conclusion that our expert did. And that conclusion is that that will was forged. Now, as the plaintiff in this case, the burden lies with us at this table. But we don't see it as a burden. No, we see it as a responsibility, and one that we'll fulfill. And that responsibility is to show you, each and every single one of you, to prove to you by a preponderance of the evidence which simply means more likely than not, that the defendant, Karen Baja, intentionally or recklessly caused the wrongful death of Mr. Donaldson, my client's father. And after all the testimony and evidence is presented to you today, after everything you hear, my co-counsel, Jasmine Matier, will stand before you and she'll review everything with you today. She'll walk you through all the evidence that you saw. And at the end of that, she'll present to you a verdict form. And she'll ask you to come to a conclusion. She'll ask you to come to a verdict that is consistent with the law, a verdict that is consistent with your own common sense, a verdict finding this defendant liable because she is.
Thank you, counsel. Opening statements from the defense.
Yes, Your Honor, one moment to set up. Permission to proceed?
Yes, when you're ready.
A girl is walking along the road. It's the middle of the night, somewhere here in Statesville. At only 17 years old, this child doesn't have much. She doesn't come from money or status. She has nothing as she walks along this dark road, and she's getting scared. As she continues to walk, she's approached by a stranger 20 years her senior, a stranger who offers her a ride. So with little option, Karen Baja accepts this ride from the stranger, Lou Donaldson. It was this chance meeting that brought Karen and Lou together, their connection that kept them together for as long as it did. Karen's hard work that helped build up their dream career. But now, Lou is gone. And as Karen has finally found some semblance of closure around his disappearance, she's being dragged into court and accused of having something to do with it. But if you just listen to plaintiff's opening, you can already see that all there is to their case is a plaintiff's grief, an emotional plea, and speculation. Perhaps it's understandable. The plaintiff said himself that Cam Donaldson loved her father, and now she needs someone to blame for his sudden disappearance. But however understandable the plaintiff's emotions may be, they are not enough to prove the case today. There is no body, there is no proof, so there is no liability. Good morning. My name is John Hobbs. I, along with my co-counsel Matthew Nunez, represent Ms. Karen Baja, the defendant today. Today, the plaintiff has a burden to prove to you by a preponderance of the evidence. That is, it is more likely than not that Karen Baja caused the wrongful death of Lou Donaldson. And they will fail to meet that burden today because past all the emotional pleas, the grief, the rumors and speculation, you will see that there is no body to prove that Lou Donaldson is dead. And there is no proof showing that Karen Baja caused his death. Now, I want to take a moment to tell you more about Karen and Lou's life together. 8 years ago, her husband disappeared, and Miss Baja has worked every day since to maintain their dream. Karen met Lou by chance. A connection formed, a connection strong enough to build up the wild wildlife Big Cat Emporium. You see, this emporium was the culmination of Karen and Lou's passion for preserving, protecting endangered species of big cats. This wasn't some fairy tale, some castle on the hill, members of the jury. This was Karen's life. A life she loved, a life she built up with her husband, a life she did not take for granted. But however strong this connection was, it was strong enough to bring them together, strong enough to build up this emporium. You will see it was not strong enough to keep them together. Karen and Lou's marriage, it wasn't celebrated by everyone. You will see that that Lou Donaldson's family, in particular the plaintiff, never approved of Karen. She didn't come from money. She didn't come from status. So to Lou's family, she wasn't worthy of Lou and his wealth. You will see today that for Lou's family, they could never forgive what they saw as the street trash that came in and ruined Lou's previous marriage. I want you to remember that when you hear the plaintiff's case today. Lou's family wasn't the only challenge Karen faced in her marriage. Prior to his disappearance, Lou had become aloof. He was a pilot with secrets, a pilot who would fly off, disappear without telling Karen where he was going or when he was coming back. I want you to listen to the testimony about how many planes Lou had. Listen to hear about his pilot's license. I want you to pay attention about the secrets he kept around his flying. Listen, and you will see that despite all of this, Karen still wanted her marriage to work. She wanted to stick by Lou's side, even though he continued to disappear and leave her to take care of the emporium by herself. And you will see today that that is what happened in August 2012. Lou disappeared. That's all we know. That's all you'll learn today. You won't see anything that proves otherwise. You won't see anything that proves to you that Lou is dead. No testimony will tell you where Lou died, when he died, where he was the days leading up to his disappearance, if anyone saw this alleged death. Moreover, you won't hear any testimony that proves to you Lou's cause of death, how he died. No testimony from the plaintiff will show you any signs of a struggle they gathered during their investigation. Not a single lead from that same investigation will connect Ms. Baja to Lou's disappearance. Nothing you learn today will be more than just a rumor. But you will see today that while Lou was gone, Karen stayed right here in Statesville. She stayed right here to maintain the dream she and Lou built up. Because this wasn't a fairy tale. This was her life. And at this point, it was her husband's legacy. And even when she did receive the proceeds of Lou's life insurance claim, she didn't cash out this lottery ticket. She stayed right here. She maintained her life. She maintained Lou's dream. As we begin today's trial, I want to remind you of something. Each and every one of you was chosen to sit on this jury because you made a solemn oath. An oath to not let pity or emotion cloud your judgment. An oath to base your opinions and your decisions on the facts and whatever proof the plaintiff can bring you today. So at the end of today's trial, you will see that there is no body to prove that Lou is dead. No proof showing Karen caused his death. No answers to the many questions surrounding his disappearance. So at the end of today's trial, my co-counsel will come before you again and ask that you return a verdict warranted by the evidence, not liable. Thank you.
Thank you, counsel. Is the plaintiff ready to proceed with their case?
Your Honor, prior to proceeding, we believe our host witness is in the waiting room.
Okay, who is that?
It's supposed to be Taylor Pride. But the real name is, I think, Justin.
I think Taylor Pride's in.
I am here.
Okay, I think everybody's in.
Thank you, Your Honor. With that, Your Honor, we are ready to proceed, and we would like to call Cam Donaldson to the stand.
Proceed when ready.
Yes, Your Honor. Good morning. Could you please state your full name for the record?
Hi, yes, good morning. My name is Cam Donaldson.
Why are you here today?
Well, I am here today as a representative of my father's estate and on behalf of my family.
You mentioned your father. Were you too close?
Extremely. My father and we had the best relationship. We spent pretty much every day together and, we worked alongside each other for 20 years.
Where did you all work at?
At Wild Wild Life. It was our family business.
Could you explain what Wild Wild Life is?
Yes, so it's an animal and big cat emporium. It was my father's dream and his passion was animals. So he worked very hard in the early stages of his life and saved enough money to open it up.
Now you mentioned you worked at Wild Wild Life as well. What exactly did you do there?
Gosh, I did absolutely everything. I mean, my father would even joke that I knew more about his business than he did. I kept the books, I scheduled his meetings, I ordered the supplies, and I managed all of the accounts.
What accounts did you manage in particular?
All of the financial accounts.
Do you still work at Wild Wild Life?
No, I don't. I was fired by Karen Baja.
You mentioned the defendant. Let's talk a little bit about her. Who is she to you?
Well, she was previously married to my father.
And when did she fire you?
It was right around the time that my father had disappeared.
Now let's talk about the last time that you were able to see your father. When was that?
It was August 17th of 2012. At about 6 o'clock in the evening, he was wrapping up from a long week at work. It was a Friday, so we were closing up shop for the weekend. And he had told me that he would see me at work on Monday, but if I wanted, I could stop by for supper on Sunday, which I had planned to do, but that never happened.
What do you mean it never happened?
Well, Sunday rolled around, and at about 6 o'clock in the morning, the alarm started going off at Wild Wild Life. So I rushed over there. I lived pretty close and I got there fairly quickly. The police followed him behind me. And when we got there, we saw Karen coming out of the office holding a lockbox. And she had some other man with her who I had never seen before. And he was holding bolt cutters.
Your Honor, at this time, we're showing opposing counsel what has been date stamped as 004 and 005. Can we verify that opposing counsel sees that?
Yes.
Your Honor, may we approach the witness?
Yes, you may.
Ms. Donaldson, do you recognize the images in this composite?
Yes, I do.
And how do you recognize them?
Well, these are photos of the cut lock that was usually on the Wild Wild Life front gate and also the back entrance that was destroyed that day.
And would you say that these images in this composite are a fair and accurate depiction of that cut lock and that hole in the back gate?
Yes, they are.
Your Honor, at this time, plaintiff wishes to move what was pre-marked as Plaintiff Composite 1 for identification as Plaintiff Exhibit 1.
Any objection?
No, Your Honor.
Your Honor, may
Those
we?
ex-
I'm sorry.
Sorry, those exhibits will be entered and you may publish.
Thank you, Your Honor. And just so we can be sure, can everyone see this exhibit?
Yes,
Yes.
we can.
And this is the first picture of the cut lock. And then this is the second picture of the hole in the back gate. Now, Ms. Donaldson, how did the defendant get into Wild Wild Life that day?
Well, like I said, the man that she had with her had bolt cutters and she cut the lock off of the front gate and was able to destroy her way in through the back gate as well.
Your Honor, may we preserve
Objection.
the,
Speculation.
Any response?
yes, Your Honor. Your Honor, may we approach?
Yes, you may.
Your Honor, this witness just testified that when she came to the scene, a place where she works at and has worked at for 20 years, the lock that is normally on the gate was cut, and the person that she observed at the scene had lock cutters in his hand. This is acceptable within a lay witness's opinion of her perceived state at the scene of this event.
And at this point, also staying based on foundation, I think the witness testified that she saw the individual, the male, holding the cutter. She did not personally witness anyone breaking in, but it's her assumption that it was Miss Baja and this man. So also staying based on foundation at this point.
Yes, Your Honor. Your Honor, may we preserve this exhibit to be used in close?
Yes, you may.
Thank you, Your Honor. Now, Ms. Donaldson, did you ever do anything else or find out anything else about the investigation into your father's disappearance?
Yes, so the police had told me that they found his van at an airstrip that was like 40 miles away that he never used, and inside had his glasses and his keys.
You mentioned his glasses. Was there anything significant about those glasses?
Yes, my father was blind as a bat without those glasses. I mean, he really never went anywhere without them, and they were his only pair. He'd actually had the same pair since I was in high school.
And did you do anything else in addition to find out what happened to your father?
Yes, I did. I hired a private investigator.
Who did you hire?
It was Taylor Pride with Pride Investigations Incorporated.
Now, I want to go back and talk a little bit more about the defendant and your father's relationship. Briefly, how would you describe their relationship?
I mean, in a word, toxic.
And why would you say that?
They fought all the time. It was just completely constant.
And were you ever able to observe any of these fights yourself?
Yes, I was. And there were a few in particular that were extremely bad. I mean, there was this one time that I overheard my father and Karen arguing in the Wild Wildlife offices. And all of a sudden, Karen just stormed out. She was absolutely furious. And it was because my father had told her that he was filing for divorce.
And were you able to speak to your father after this fight?
I was, yes. And I was very concerned for him. I mean, when he came out, he was very visibly shaken, and I had never seen him that way before. My father and I spent pretty much every day together, and I had never seen him like this. So when I tried to console him and kind of ask him what was going on, he told me that if anything were to ever happen to
Objection.
him,
Calls for hearsay.
Any response?
Yes, Your Honor. Your Honor, may we approach?
Yes.
Your Honor, the prior testimony of this witness was that her father had just experienced an exciting event, a fight between him and his wife, and that he was in a state that she had never seen him before. This witness sees her father every day for the past 20 years at work, and therefore this falls under the exciting utterance exception for hearsay.
Your Honor, if I may be heard.
Yes.
This is a conclusory statement by this witness. Just because she uses a buzzword doesn't mean there's a proper foundation. Additionally, I have another objection to relevance. The statement that Lou Donaldson says is irrelevant. Additionally, it's speculative. He's speculating as to what could happen.
Can someone tell me what the statement is? I'm sorry.
Yes, Your Honor. Would you like for me to tell you?
Yes, please.
Your Honor, Lou Donaldson, who is the victim in this case, he told his daughter that if anything were to ever happen to him, it would be the defendant, Karen Baja, that was responsible for what happened to him.
So I think the defense just objected to relevance and speculation and as well as hearsay.
Additionally, that wording is substantially more prejudicial than it is probative. Should the jury hear it's a bell that cannot be unrung, and they will take it for its truth.
Any response by the plaintiff?
Yes, Your Honor. Your Honor, again, this statement was made after experiencing an exciting event. We laid the foundation to establish that there was an exciting event, which was the fight that the witness heard, as well as the state of her father, who she has been in contact with every day for 20 years. In addition to that, this statement is relevant. This is a statement by the victim about his perception and how he felt after that argument with the defendant. And furthermore, Your Honor, this statement goes to show that it was the defendant, Ms. Baja, who at this point was triggered. Her motive for committing this crime, the fact that her husband was mad and angry and upset with her and was about to leave her, which caused her to want to create this crime or to cause this wrongful death.
And Ms. Matier, can you respond to the 403 objection as well?
Oh, yes, Your Honor. Your Honor, this statement, the probative value of this statement farly substantially outweighs any unfair prejudice that this statement could cause, and therefore it should be heard by the members of the jury.
Last word, Mr. Nunes.
Your Honor, I stand by the objection we made. It's substantially more prejudicial.
I think at this point, I'm going to allow the statement in. It pretty clearly shows the victim was scared of the defendant, his state of mind. I will, however, provide a limiting instruction to the jury that they are the ultimate determiners of what happened in this case. They are the ones responsible for deciding who was responsible, obviously, for the death, and that this statement should not be taken as conclusory evidence of that.
Yes, Your Honor.
Yes, Your Honor.
So at this point, the objection is sustained in part. You may continue.
Yes, Your Honor. Now, Ms. Donaldson, I'm going to ask you that question again. What did your father tell you when you were able to speak to him?
well, like I said, he was very visibly upset. And when I asked him, what was going on or how I could calm him down, he told me that if anything were to ever happen to him, to ensure that the authorities look to Karen because she would ultimately be the one responsible.
And you mentioned that you observed multiple fights. Were there any other fights that you were present for?
Yes, there were many, but I mean, another one in particular, it was just a few weeks before my father had gone missing. He actually attempted to file for a restraining order against Karen, because she had been making death threats against him.
Now, Ms. Donaldson, let's move on back to that lockbox that you mentioned earlier. What exactly was inside of that lockbox?
That lockbox contained my father's last will and testament.
And do you have a copy of that will with you today?
No, I don't. That morning at Wild Wild Life, the police questioned Karen and she ended up leaving with the lockbox, so she took the will with her.
And did you inherit anything after your father disappeared?
No, I mean, a few weeks after he disappeared, Karen came forward with some document I'd never seen before, and she claimed that it was my father's last will and testament. And in this new document that she provided, she got everything.
What do you mean by everything?
All of my father's assets and my father's $5 million life insurance policy.
So in total, how much did Karen end up getting?
It was $10 million in total, $5 million from my father's assets and $5 million from the insurance policy.
And earlier, Ms. Donaldson, you mentioned that you ran your father's accounts. Has your father spent any money since he went missing in 2012?
No, there have been no transactions from any of my father's accounts since the day he went missing.
Your Honor, a moment to confer.
Yes, you may.
No further questions, Your Honor.
Cross-examination by the defense.
Yes, Your Honor. Permission to proceed?
When you're ready.
Now, Ms. Donaldson, you testified that the alarm went off at Wild Wildlife in the morning, correct?
Yes, that's correct.
This was on August 19th of 2012, right?
Yes, it was a Sunday.
You claim you saw Ms. Baja there that morning, correct?
Yes, her and another man who I'd never seen before.
You didn't bring us security footage showing that Ms. Baja had the lockbox, correct?
I don't have any knowledge of any security footage.
Well, you just testified that you knew the company more than your father did, right?
I did, yes. I worked there for 20 years, but I have no knowledge of any information of security footage.
So you have no knowledge if the place you helped run day to day had security camera footage?
I have no knowledge of that information.
Okay. You didn't think of take a picture of Miss Baja with your cell phone that night, right?
That morning?
That morning, excuse me.
No, I did not take a photo.
You took a photo of a lock and a gate though, correct?
I didn't take those photos.
Okay. I want to talk to you a little bit about your role at Wild Wildlife.
Sure.
You used to work there, correct?
Yes, for 20 years, I was my father's assistant.
That's right. You were your father's assistant for 20 years.
Yes.
You'd say you worked hard those 20 years?
Absolutely. I mean, it was a family business and it took everything for us to maintain it and continue it and have it prosper.
So that's a yes to my question?
Yes.
You would say you relied on your father financially, correct?
No, our business was very successful and I worked hard and made my own money.
He paid your paycheck though, correct?
No, the business of Wild Wild Life paid my paycheck.
And he owns that business, correct?
Yes, we operated it together.
So you relied on him to pay your paycheck, correct?
No, I relied on the success of Wild Wild Life to pay my paycheck.
All right, Mrs. Donaldson. You're currently unemployed as we speak.
I don't have any knowledge of that information.
You don't know if you're working right now?
I don't have any knowledge related to my current employment state, no.
You also then have no idea that whether you have an income right now.
I have no knowledge of that information.
Okay. It was your belief that you would inherit part of Wild Wildlife, correct?
Yes, I mean, in my father's actual will, he had split his assets 4 different ways.
So that's a yes to my question?
Yes.
All right. And that business was worth $5 million?
Yes, his assets.
You didn't inherit anything though, right?
No, not based off of the fraudulent document that Karen provided.
So that's a no to my question. You didn't inherit anything, right?
Yes, that's what I said.
All right. Now you got, excuse me, withdrawing. Miss Baja got everything, correct?
Yes.
And here today you are suing Miss Baja.
Yes.
You want to recover $10 million, right?
I want to recover what Karen stole. Yes.
So that's a yes to my question. You want to recover $10 million.
Yes.
Now I want to talk to you about your father's relationship with Miss Baja. Now, to be clear, you never saw Karen Baja hit your father, correct?
I don't have any knowledge of that information.
All right, well, you also testified that you spent most days with your father, correct?
Yes, almost every day.
And you never saw bruises on him, right?
I have no knowledge of that information.
Oh, okay. All right, fair. So you also never saw any scratches on your father?
I have no knowledge of that information.
You never saw Karen Baja get physical with your father, correct?
Again, I have no knowledge of that information.
You didn't see your father on the day he disappeared, right?
The last day that I saw my father was August 17th, and that was the last day that he was ever seen by anyone.
So that's a yes to my question. You did not see him on the day he disappeared.
If you're referring to the 18th, no.
In fact, you never saw Karen Baja that day either, correct?
Correct.
To your knowledge, your father's never called the police on Karen Baja, correct?
I don't have any knowledge of that information, but my father did go to the courthouse to try and get a restraining order against her.
I understand that's your claim, but directing you just back to my question, to your knowledge, your father never called the police on Karen Baja.
I don't have any knowledge of that information.
All right. You didn't bring us an invoice for a divorce attorney, correct?
No, I don't have any knowledge of any of that information.
Well, we also just established that you manage your father's bank accounts, right?
I do, yes, and all of the Wildlife financials.
Yeah, and you check those accounts daily, right?
Regularly, yes.
And you have never seen an invoice for a divorce attorney, correct?
I have no knowledge of that information.
Your father never asked to stay with you, right?
As in to live with me?
Correct.
I don't have any knowledge of that.
Your father never asked you to move in with him?
I have no knowledge of that information.
Okay. And on your father's bank statement, you never saw a receipt for a motel either, correct?
Not on any of the statements that I have brought today.
So that's a no to my question.
Not on any of the statements that I have brought today, but there may have been on some of his other statements. I don't have a 100% confirmation of that.
So you're saying your father had other bank statements?
Well, there were many accounts, but the statements that I've brought today don't have any receipt of a motel.
Okay. As far as you know, your father stayed living with Karen Baja, correct?
I believe so.
So that's a yes to my question.
Yes. I don't have any information as to whether or not he had ever moved out or they had separated at any point.
All right. Now let's talk about your father a little bit. Your father was a pilot, right?
Yes, he loved to fly and he would oftentimes buy and sell planes. It was one of his hobbies.
You can't tell us how many planes your father owned, correct?
That's correct. I mean, like I just said, he oftentimes bought and sold planes and it was one of his kind of side activities.
So that's a yes to my question. You didn't know how many planes he owned, right?
That's correct, not the total number.
You additionally don't know where he stored all these planes, correct?
Well, I do know that he stored them at a variety of different hangars, but I don't know the specific locations.
To be clear, we established you don't know how many planes he has, right?
Yes, that's correct.
But you're claiming to know where all his planes are.
No, that's what I just said, is that he stored them at a variety of different hangars, and I don't know the specific locations.
You're aware that your father had his pilot license suspended, correct?
Yes.
That didn't stop him from flying though, right?
No.
You would agree that your father would fly under the radar, right?
Yes, he would oftentimes fly without logging a flight plan, but he would always check in with me and give me the details of his planned trips.
So that's a yes to my question. He would fly under the radar.
Yes.
He wouldn't log his flight with the proper authorities, correct?
Correct, but as I did say, he would always tell me before he flew.
Additionally, you're aware and you testified on direct that your father's glasses were found in his van, correct?
Yes, and those were his only pair.
And you claim they were his only pair, right?
Yes.
He was blind as a bat without them.
Yes, he'd had the same pair since I was in high school.
And you're aware that those glasses were found in a van at an airstrip, correct?
Yes, and he would never fly without his glasses. That's what concerned me.
So that's a yes to my question. The glasses were in the van at the airstrip, correct?
Yes, that's correct.
Now, your father went missing in August of 2012, right?
Yes, that's correct.
You hired a private investigator in July of 2017, correct?
Yes.
That's about a 5-year difference.
Yes.
In fact, you hired a private investigator after you found out Miss Baja was inheriting everything, right?
Yes.
All right, now I want to talk to you about Karen Baja just a little bit. Karen Baja, that's your stepmother, correct?
Yes, she was married to my father.
You never liked her though, right?
I mean, truthfully, I didn't really have any problem with Karen up until she started profiting off of my father's disappearance.
So you never really liked her, right?
No, I really had no problem with Karen up until, she started benefiting from my father being gone. That's when things kind of went sour.
Well, wouldn't you say that you thought she was with your father for the money?
I definitely, had my concerns just because I was looking out for my father, but I really didn't have any significant issue with Karen up until, he disappeared and she started taking everything.
Your father divorced your mother for Karen Baja, right?
Yes.
You had no issue with that.
Their relationship was their own. And, I just wanted what was best for my father. I wanted my father to be happy.
Well, it's safe to say, based on your claims, that you hate Karen Baja, right?
Well, she is the reason for my father's disappearance. And, she took my only father that I would ever have. So yes, I really have a distaste for her.
Yeah, you claim that she's the reason for your father's disappearance. You hate her for that, correct?
Yes.
You actually wish she would be eaten by one of her tigers, right?
I have said that in the past, out of grief, and I was very upset. But yes, I have said that.
No further questions, Your Honor.
Any redirect?
Yes, Your Honor. Ms. Donaldson, how did you know what was inside of the lockbox?
Well, like I said, I was my father's assistant for 20 years, and I managed all of his accounts, all of his records, all of his documents. And beyond that, I kept his last will and testament in that lockbox, locked in the bottom drawer of my desk at Wild Wildlife.
And you were asked during cross about some comments that you made about the defendant. Why did you make those comments?
Well, like I said, I mean, I really had no problem with Karen up until she started profiting off of my father being gone. So I made those comments in, a moment of frustration and sadness and sorrow because I only had one father and now I'll never get to see him again. So yes, I said those things, but I think that, you have to kind of just understand the place that I'm in.
Your Honor, no further questions. This witness may be dismissed.
From the defense, may this witness be excused?
Yes, Your Honor.
Does the plaintiff have an additional witness?
Yes, Your Honor. At this time, call to stand Taylor Pride.
You can begin when ready.
Good morning. Can you please turn and introduce yourself to the jury?
Hi, my name is Taylor Pride. Last name is spelled Pride.
Mr. Pride, before we take any further questions, can you hear me fine?
Yes, I can hear you.
Well, Mr. Pride, before we get to why you're here today, I want the jury to get to know you a little bit better. So where do you currently work?
So I am independently employed at this point. I'm a private investigator. I own my own firm called Pride Investigations, Inc.
And what did you do before starting your own investigation firm?
Well, I worked for the Providence Police Department, Pioneer Police Department as a detective for a few years, for 16 years, actually.
And in those 16 years, what would you investigate?
I investigated a range of cases. I mean, obviously, there were some, economic crimes that we investigated, all the way up to murder.
Well, Mr. Pride, you just mentioned economic crimes. What economic crimes would you look at?
I spent a lot of time, and I kind of specialized in investigating forensic crimes.
And did you have to receive any type of training to look at these forensic crimes?
Yes, I have been trained to analyze and compare handwriting samples, do handwriting analysis, stuff like that. I've also been certified by the American Board of Forensic Document Examiners.
And now that you're in your own private practice, have you had a chance to participate in any continuing education?
Yes, so I attend annual courses to stay up to date on the latest methods and stuff like that, and then I have to recertify with the board every 4 years.
All right, and now that we've talked about what you've done outside of the courtroom, what about inside? Have you ever testified in court before?
Yes, I have.
In what capacity have you testified as?
I have testified as an expert in the area of handwriting analysis and document examination a total of 15 times since the year 2002.
Let's switch gears now and talk about why you're here specifically today. Why are you here today?
Well, I was hired by Cam Donaldson to do two things primarily. First, I was hired to analyze the alleged last will and testament, see if that was fraudulent. And the second thing I was hired to do was to investigate the disappearance of Lou Donaldson.
All right, well, you just mentioned two separate investigations. Were you able to complete both of those?
Yes, I was.
Without going into detail, were you able to come to any conclusions?
I was.
And was the evidence that you relied upon evidence that is usually relied upon by experts in that field?
Yes.
And what type of evidence does that usually compose of or consist of, my bad?
I looked at bank records. For the investigation into Mr. Donaldson specifically, we sent an investigator down to Costa Rica to look for him. I analyzed handwriting samples on the last will and testament, as well as the actual documents, the language that was contained in the document.
All right. Your Honor, may I approach?
Yes, you may.
Your Honor, at this time, the plaintiff would like to tender this individual as an expert in handwriting analysis and forensic documents, as well as investigation.
Any objection or voir dire?
Yes, Your Honor, we object to that last part, investigation. That is too broad of a tender pursuant to Rule 702 of the Federal Rules of Evidence.
May I respond, Your Honor?
Yes, you may.
Your Honor, Mr. Pride has just testified that he is an investigator. He owns his own investigation firm. He was a detective for 16 years. As a detective, it ranged from economic crimes to murders. All of this is in the art and in the field of investigation. Now, if it'd be more specific, we could talk about the investigation solely of Mr. Donaldson and looking into the disappearance of an individual. We can tender him in that. However, we do not believe that this is too broad a scope based on the foundation that we have laid.
Mr. Hobbs, final word.
Yes, Your Honor. That did not address the vagueness and the broad of this scope. We don't know what investigations the specificity and expertise will delve into. That's our position.
Your Honor, may I briefly respond?
Sure.
Your Honor, we have limited the investigation to simply where Mr. Donaldson is. A material fact at issue is whether or not he's disappeared or he's dead. And this witness has testified that that is what he was hired to do. Therefore, this jury isn't going to have a broad explanation. They simply know that this individual looked into simply the disappearance of an individual.
Thank you, counsel. I agree with the defense. It is a broad tender. However, I think it's very clear the investigation will be limited in this case. So I will accept Mr. Pride as an expert in forensic handwriting analysis as well as investigations. Obviously, Mr. Hobbs, if you believe he's exceeding the scope and going into some outside investigation, feel free to object.
Yes, Your Honor.
Very well. Mr. Pride, let's talk about your first investigation. That's the analysis of Mr. Donaldson's alleged will and testament. What conclusion did you come about this?
Yeah, so it was my opinion that the alleged will and testament was in fact a forgery.
Let's talk about how you came to this determination. What steps did you take to reach this conclusion?
Well, I performed a step-by-step analysis basically to verify the signature that was on the last will and testament.
Walk us through that analysis. What was the first thing you did?
Yeah, so first I wanted to obtain kind of a baseline sample of Mr. Donaldson's signature so that I could become familiar with his handwriting patterns.
Your Honor, may we approach?
Yes, you may.
Your Honor, at this time, we'd like to call court and counsel's attention to what has been previously bait stamped for identification as Exhibit 007 and 016. These are the two samples that Mr. Pride used to analyze the will. Your Honor, at this time, we'd like to offer the exhibit that the plaintiff has made and that has been stipulated to as a composite exhibit.
Any objection again by the defense?
No, Your Honor.
That exhibit will be admitted and feel free to publish.
Yeah. And point of clarification, Your Honor, may we also admit those two exhibits individually as well?
Any objection by the defense?
It was a signature on the TRO. So you're trying to be clear, you're trying to move in the TRO itself.
Yes.
We object to that, Your Honor.
I agree at this point. I'll sustain. I don't think there's been any foundation laid that this witness has any personal knowledge. I understand he probably used it to come to a conclusion in his expert opinion. However, that foundation has not been laid. So based on foundation, I'll sustain. If you'd like to lay further foundation, I'll take up further objections.
Your Honor, for now then, we're just going to use the signature. And in the proceeding of this direct, we'll get into that later then, Your Honor.
Okay, and that's the stipulated exhibit, correct?
Right now, we'll just present the stipulated exhibit, Your Honor.
Okay. And feel free to publish that.
Mr. Pride, do you recognize this?
Yeah, I do.
How do you recognize this exhibit?
This is a signature example that I analyzed of Mr. Donaldson's.
And are they in the same or substantially the same condition as the last time you saw them?
Yes.
No, we move into evidence this exhibit now.
Any objection?
No, Your Honor.
It's admitted and it may be published.
Thank you, Your Honor. Mr. Pride, can you confirm once those two samples appear on your screen?
That's correct. I can see them.
So you mentioned that you had to collect these two samples. What was your analysis when you compared these two samples?
It was my analysis that these two samples matched. You can see that there are a lot of similarities between the two signatures, specifically the way the letters Lou are written. Additionally, you can kind of see, if you look at the last O in Donaldson, it kind of peaks at the top, and that's what we call a lazy letter in the industry. It's clearly written towards the end of signatures.
All right, and just to clarify, Mr. Pride, the lazy O that you're discussing is here?
Yes, right there.
The other lazy O that you're discussing?
Your Honor. At this
Yes.
point, counsel is testifying.
Your Honor, may we approach?
You may.
Your Honor, this would be no different than if we were in real life using a laser pointer or just clarifying with our finger. Just because of the technology that we have at this point, we're limited to a cursor.
I agree. The objection's overruled.
Now, Mr. Pride, besides the individual letters in these signatures, were you able to find any more similarities?
Yeah, the writer rarely lifts their pen, so you can tell by how they just kind of loop their letters. There's no distinct pen marks on there at all. It's pretty consistent.
Bro. Now, Mr. Pride, what did you do after you analyzed those two?
So I took the two known samples that I had and I compared those to the sample that was the one in question, specifically the one on the will.
Your Honor, may I approach the witness with an exhibit?
Yes, you may.
Calling court and counsel's attention to what has been previously bait stamped for identification as Exhibit 14. This is the last will and testament. Opposing counsel. Mr. Pride, do you recognize this exhibit?
I do, yes.
How do you recognize this exhibit?
This is the signature that was in question that I analyzed.
And is it in the same or substantially the same condition as the last time you saw it?
Yes.
Your Honor, we now like to offer into evidence what has been previously bait stamped as Exhibit 014 as defense Exhibit 2, or 3, or plaintiff exhibit.
Any objection?
No, Your Honor.
Exhibit 3 shall be entered and feel free to publish.
Your Honor. Mr. Pride, can you confirm once the last will and testament appears on your screen?
Yes, I can see it.
Great. So once you took those two samples, and then you compared to the handwriting in question, what was your analysis on that?
If you could zoom in a little on the Lou Donaldson, I could tell that the person who signed this lifted their pen a lot more frequently when they did this. The person who signed this also doesn't use that lazy letter in the last part of Donaldson. You can see that in that Donaldson, it's just a straight O. There's also some pen marks on there that indicated that to me that somebody was lifting the pen up pretty frequently.
Well, and now moving on past the signature on the will, Mr. Pride, did you have a chance to look at the language of the will?
I did analyze that as well.
And did anything stand out to you when you analyzed the language of the will?
I was concerned with the language die or disappear. To me, that stood out as odd.
And why is that?
I've looked at a few wills in my career doing this type of stuff, and I've never seen the term disappear used in a will before.
Now, Mr. Pride, I want to switch gears from the language of the will and discuss the other signatures besides Mr. Donaldson, the two witnesses' signatures. Who were the witnesses on this will?
The two witnesses to this will were Samantha Lane and Karen Baja.
And I first want to draw your attention to Samantha Lane. What do you know about Miss Lane?
I was able to contact her when I was doing my investigation into this. You know, obviously one of the things that we do is interviews, right? So I contacted her and spoke to her about her involvement in this will signing.
What did you learn from this conversation with Miss Lane?
Objection, Your Honor. Calls for hearsay.
Will the parties approach? And Mr. Tucio, can you give me an offer of proof? What will this witness say?
Yes, Your Honor. If this witness testifies in accordance to your deposition, they will explain how during their investigation process, they were able to speak with Miss Samantha Lane, and that Miss Lane said that she was coerced into signing the will, that she was threatened by Ms. Baja, and then she'll go into the specific threats of the defendant. Your Honor, if I may respond to the hearsay objection?
Yes, please.
First and foremost, Your Honor, this is an expert in handwriting analysis, and this is part of their investigation. And an expert is allowed to rely on hearsay. And furthermore, Your Honor, this individual is testifying, or Samantha Lane is testifying in a way of a statement that goes against her interest. She's talking about how she was coerced into signing a will. And because of this, she's admitting to be partaking in forgery. And this exposes her to civil and criminal liability. And she's not here to testify, Your Honor. For these two reasons, it does not fall under hearsay.
Response by the defense.
Now, there are two layers of hearsay. The layer of hearsay I'm addressing is one from Samantha Lane, which is hearsay without exception. Secondly, this cannot come in as a basis of the expert's opinion, as the plaintiff has failed to show the reverse balancing test has been met in this situation. They have failed to show that this testimony from Samantha Lane is substantially more probative than it is prejudicial. The threat of unfair prejudice in this statement by these alleged statements from Ms. Baja is paramount.
Your Honor, may I respond to,
Yes, please, last word.
Your Honor, this testimony its probative value substantially outweighs any prejudice that opposing counsel is trying to present. Your Honor, a material fact at issue today is whether or not Karen Baja killed Mr. Donaldson. Your Honor, a forged will giving her all of the estate is clear motive for this individual to kill Mr. Donaldson. This testimony is going to tends to prove the fact that this will was forged, which was one of the motives that this defendant had to kill Mr. Donaldson. Therefore, the jury cannot view this case in a vacuum. This is substantial evidence and will benefit from hearing this, as they will see the motive and how she was able to plan forging this will. Therefore, Your Honor, this is not prejudicial in any way.
I think at this point, I'm going to split the baby a bit. It sounds like these are statements that were relied on by the expert to come to his expert opinion. Further, it sounds like some of these statements are not hearsay. They lead to the effect on the listener. That said, some of these statements, the specific threats, although I was not told what they are, may be prejudicial. So at this point, I'll allow the witness to discuss that threats were made to this particular witness, that she felt threatened, but not go into the specific threats that were made to her. Does that make sense to the parties?
Yes, Your Honor.
Please proceed.
Mr. Pratt, I'll ask that question again. What were you able to learn from that communication with Ms. Lane?
So when I spoke to her, she informed me that she had been coerced into signing the will by being threatened by Ms. Baja.
Let's move on to your investigation regarding Mr. Donaldson's disappearance. What was your conclusion regarding his alleged disappearance?
So my conclusion into that was that Karen Baja was somehow involved in the death of Mr. Donaldson.
Objection, Your Honor.
What's the objection?
Permission to approach.
You may.
Although Mr. Pratt was tendered as an expert in investigations, this conclusion goes to the ultimate issue for the case today, and thus cannot be given by this expert. This is still a question that's remaining for the jury and for the jury alone.
Response?
Yes, Your Honor. Pursuant to Federal Rule of Evidence 704, just because an individual opines on an ultimate issue, it is not justified to object to this. Second, Your Honor, this individual is not going to state that, or this expert is not going to state that Karen Baja killed the defendant. If we hear what this expert just said, is that she was involved in the disappearance of Mr. Donaldson. This is not a material, or this is not the ultimate issue in today's case, Your Honor.
I agree with the plaintiff at this point. This does not quite go to the ultimate issue to the extent that he does testify to the ultimate issue. I will provide the jury with a limiting instruction similar to earlier, that it is their sole responsibility to decide who is at fault in the death of the victim in this case.
Yes, Your Honor.
Please.
Let's talk about how you came to that conclusion, Mr. Pride. What evidence did you consider when coming to this conclusion?
So one of the first things that I looked at was, or I considered, was the restraining order that was attempted to be filed by Mr. Donaldson.
Your Honor, may we approach?
Yes, you may.
Your Honor, at this time, we'd like to reintroduce the restraining order. We know that you said that to bring it to your attention later on. At this time, Your Honor, we're going into this expert's opinion on the disappearance of Mr. Donaldson and the restraining order. Your Honor, this restraining order is a crucial piece of evidence to today's case. As we already established, a material fact that issues whether or not Karen Baja killed Mr. Donaldson. Now, mention of this restraining order will show that he filed for a restraining order on June 12th and then allegedly signed a will giving everything to a woman he tried getting a restraining order from just 2 days after. Your Honor, once again, the jury cannot view this case in a vacuum and would substantially benefit from hearing this evidence, as it will show that the defense is trying to prove or present him an absurd claim that this will was signed by Mr. Donaldson.
Any objection by the defense?
Yes, Your Honor. This restraining order is hearsay within hearsay. Would
Can you explain that for me? Yes, please.
Yes, Your Honor. The first layer of hearsay is a restraining order itself, which is hearsay without exception. Second, the statements on specifically the claims by Lou Donaldson, going to his fear of going to the threats Ms. Baja allegedly made against him, are hearsay without exception as well.
May I respond, Your Honor?
Yes, you may.
In regard to the restraining order, this is a court document that was filed in this jurisdiction. You can take, or the court can take judicial notice on this. Further, Your Honor, as to the statements from Karen Baja, that goes for opposing party, and then the individual statements of Mr. Donaldson show the present, then existing state of mind that he had of, he felt afraid. It also shows the effect it had on the listener of, that is why I am attempting to get a restraining order because of Ms. Baja. Therefore, this does not fall under hearsay, Your Honor, or it is an exception to the hearsay rule.
I agree with the plaintiff that I don't think hearsay is an issue at this point, given the exceptions they laid out. Does the defense have any further objection?
Yes, Your Honor, this is not a, excuse me, Your Honor, we stand by our objection. This is not a public record within the confines of 803.8. This cannot come in for its truth value. Furthermore, the statements by Lou Donaldson himself are speculative and only go to the effect on the listener and cannot come in for its truth value.
Mr. Tusio, I do have some concerns about this being potentially a violation of 404B, propensity. Can the plaintiff speak to those issues? I'm with you on the hearsay. I think it comes in under those exceptions you laid out. But can you speak to me on the propensity rule?
Yes, Your Honor. Pursuant to Federal Rule of Evidence 404, passing the propensity argument, Your Honor, some of the exceptions to this is that there was a motive or intent or plan. Your Honor, this shows that Karen Baja had the intent to kill Mr. Donaldson. The threats that are listed herein is the fact that she said that she threatened Mr. Donaldson, that she would kill him. This is blatant intent and shows that she did intend to kill Mr. Donaldson. However, if Your Honor finds that this is in any way prejudicial, we can stipulate to extracting these statements from the TRO and just submit the TRO for itself and the date that it was filed.
Does that stipulation satisfy the defense?
So the stipulation would be removing all three statements from the TRO and just having the TRO itself?
Yes, just the date that the TRO was issued or not issued. I'm not sure. I've learned if it was actually put in place or not, but just the date.
Yes, Your Honor, we're fine with the three statements being removed and the TRO date and the fact that it was denied be entered.
And the fact that it is a restraining order, just to clarify.
Yeah, I accept the party's stipulation in this case. I do not think that this particular document violates hearsay in any way. Obviously, I'm concerned that statements that the defendant may have threatened to kill him before and then is being used as proof that she killed him in this case may come into evidence. So I will accept the TRO into evidence with the constructive redactions, obviously, and I will let the parties proceed and publish that at this time.
Your Honor, one more point of clarification.
Yes.
Your Honor, may we explain that this was a restraining order towards Karen Baja?
I think that's coming in the caption for the case, that it is a restraining order against Karen Baja, that it was ultimately denied, and then obviously the date of the restraining order. To the extent the plaintiff would like to publish that, I think the parties can agree to constructively publish that to the scoring jurors, and then at this point you can proceed.
Thank you, Your Honor. Mr. Pride, regarding the restraining order, what did you learn when you analyzed what did you learn from this restraining order?
So I learned that there was a restraining order filed against Karen Baja just a couple days before he ended up disappearing.
Now, just to be clear, what date was this restraining order filed?
June 12th.
And I now want to draw your attention to the alleged will that we had discussed before. What date was that will filed?
June 14th. I apologize. I misspoke earlier. It wasn't before he disappeared. It was before he signed the will. He filed the restraining order 2 days before he signed the will, not before he disappeared. My bad.
No worries, Mr. Pride. And so just to clarify for the jury, how many days after Mr. Donaldson attempted to get a restraining order did he then allegedly sign a will?
2 days.
Moment to confer, Your Honor.
Yes, you may.
No further questions, Your Honor.
Cross-examination, Mr. Hobbs.
Yes, Your Honor, one moment. Permission to proceed?
Yes, you may.
Mr. Pride, you were hired as a private investigator for this case, correct?
Correct.
You were hired to look into Lou Donaldson's disappearance.
Correct.
The plaintiff hired you, right?
Yeah, Cam Donaldson hired me.
They didn't hire you in 2012 when Lou first disappeared, correct?
No, they hired me in, after all of this went down in 2015, I believe.
In fact, you were actually hired in 2017, correct?
Correct, 2017. You're right.
Just a month before Karen Baggio could collect Lou Donaldson's life insurance claim, right?
That's right.
The plaintiff is paying you to testify here today, correct?
Testify about my findings, yes.
Now, in conducting your investigation, you received some information from the plaintiff, right?
Could you be a little more specific as to what that information is?
Yes. Specifically, the plaintiff told you about Ms. Baggio's alleged break-in into the Wildlife Emporium, correct?
That is correct, yes.
You weren't there to see this alleged break-in, right?
No,
You don't have for the jury today security cam footage showing this break-in.
no,
You don't have a statement from Ms. Baggio explaining her side of the story, do you?
no,
You don't have a police report that might have been filed by the sheriff who responded to this alleged break-in, correct?
no. I attempted, but the police had the case file still active, so I couldn't get into that.
So that's a no to my question.
It wasn't for a lack of trying. I just couldn't get to the file.
I understand there's a lot you might want to get out, but that's a no to my question. You don't have a police report from that.
I was unable to ascertain a police report.
So you don't have it for today for the jury.
I can't get one. No.
Okay, let's talk about your handwriting analysis. You used 2 samples in analyzing the executed will, correct?
I did, yeah.
On direct examination, withdrawn. But you also had a 3rd handwriting sample from Lou Donaldson, right?
Are you talking? I don't understand. I've got one from the driver's license and one from the will.
But you also received a 3rd sample from Cam Donaldson in the form of a note, a handwritten note from Lou Donaldson, correct?
Yes, I did.
On direct examination, you did a signature analysis of Lou's handwriting, right?
That's correct.
Nowhere in that analysis did you discuss the handwriting in that note from Lou Donaldson, correct?
No.
That handwritten note from Lou Donaldson was from May 2012, right?
Supposedly, yes.
Just a month before the executed will.
Yeah.
And to be clear, the plaintiff gave you this note from Lou Donaldson.
She did.
You don't have a copy of that note today for the jury, do you?
No, I did not bring one.
You haven't provided anyone a copy of this note, right?
No.
Sitting here today, you can't tell the jury the similarities between the handwriting in that note to the handwriting on the will, right?
No.
Those similarities could have impacted your opinion about the validity of the executed will, correct?
They could have, but they didn't.
But you don't have a copy for that note today, correct?
Objection, Your Honor.
No.
Answered.
I'll allow some leeway here, so overruled.
Let's talk about your investigation of Lou's disappearance. You looked into it for about 3 years, correct?
That's right.
You're aware that Lou worked at the Wildlife Big Cat Emporium, right?
Of course.
Spent a lot of time there, right?
Yes.
You don't have for the jury today any witness statements from the Emporium's employees, right?
Other than Cam Donaldson, no.
Yeah, just Cam Donaldson, correct?
Right.
You don't have a report detailing the search you conducted of the Emporium's grounds, correct?
I don't believe I conducted a search of the Emporium grounds.
You would agree that a search of Lou's business and the grounds could have been relevant to your investigation for his disappearance, correct?
Not that many years later, I don't agree with that.
So you as a private investigator do not think it's relevant to search the target of your investigation's place of work?
As you pointed out, I started this investigation much later after he disappeared, so it wouldn't have been of any value.
So that's a no to my question.
Sure.
Is that a no?
Your Honor, at this point, the witness has already answered that question.
Your Honor, sure, that's a vague answer. It can confuse the jury.
I'm a little confused as well. Why don't you re-ask your question and we'll see what the witness is answering.
You don't have a report, excuse me, Your Honor. Your testimony today is that it's not relevant for a private investigator to search the place of business of the person he's investigating?
With the understanding that I started this investigation years after he disappeared, no, it would not be relevant.
So that's a no to my question.
Not exactly, but with the little caveat I gave, sure, it's a no.
You would also agree that it could have been relevant to your investigation if a witness statement had details about Lou's possible whereabouts.
Yeah.
I want to talk about another part of your investigation. You claim to have sent an employee down to Costa Rica to look for Lou, and they couldn't find anything, correct?
That is correct.
You didn't bring for the jury today a detailed report showing each step this employee took in looking for Lou, right?
No, there's no report that I have.
You don't have witness statements from airport employees in Costa Rica, correct?
I have no knowledge of that.
You sent an employee down to Costa Rica and you have no knowledge if they spoke to airport employees?
No.
You don't have a list of the refueling stations this employee visited and searched between here and Costa Rica, correct?
No.
You don't have witness statements from the employees at those refueling stations, do you?
No.
Sitting here today, you can't even tell us this employee's name, correct?
No.
You're aware that Lou was a pilot, right?
Yes.
And his van was found at an airstrip, correct?
Correct.
You didn't bring for the jury today security cam footage from that airstrip, correct?
I don't even know if that airstrip has cameras, honestly. So no, I don't have security footage.
Wait, to be clear, you don't know if the airstrip where Lou Donaldson's van was found has security footage?
No, I don't have any knowledge of that.
And you were hired to investigate his disappearance?
That's right.
You don't have any witness statements from those airstrip employees, do you?
No.
It could have impacted your investigation if an airstrip employee saw a plane taking off in the early morning of August 18th, correct?
I guess, yeah, it could have.
It could have also impacted your investigation if there was security cam footage showing that plane taking off, correct?
Sure.
Let's talk about what else you don't know. Sitting here today, you don't know how many planes Lou had, correct?
No.
You don't know where he kept all of his planes.
No.
You don't know if any of his planes are missing.
No.
You don't have traffic cam footage from the area surrounding the airstrip.
No, I don't.
Sitting here today, you can't even tell us where in Statesville you looked for Lou, right?
I guess not. I don't know. I mean, I obviously spoke to the police department and stuff like that, but I don't understand what you would want me to look for.
You're a private investigator and you don't know where you would look in Statesville for Lou Donaldson? Is that right?
No, I don't understand what you're getting at with that question. I did talk to people around Statesville, obviously Cam Donaldson, so I did kind of look around Statesville.
But sitting here today, you can't tell us where specifically in Statesville you searched for Lou Donaldson, correct?
Other than the airport, Cam Donaldson, the police, no, I can't give you crossroads.
So wait a minute, you just said that you searched the airports, correct?
Apologies, I had photographs I had from the airport, yes.
But you didn't actually search these airports as we established before, correct?
I guess I didn't look at security camera footage from the airport like you wanted.
You're a private investigator, right? You were hired by the plaintiff to look for his father, correct?
Right.
Well, what about Lou's friends? You don't have witness statements from his friends about his possible whereabouts, do you?
I don't have statements, no.
You don't have statements from his neighbors?
No statements.
You don't have a statement from his ex-wife?
No statements.
No statements from his family except the plaintiff, correct?
I guess not.
the plaintiff who's paying you to testify today, right?
Right.
You knew you were testifying today, right, Mr. Pride?
Yes, of course I knew I was testifying today.
And you knew you had 3 years to complete your investigation, get all the facts you need before you testified today, correct?
And I certainly did that. I had everything I needed.
So that's a yes to my question. You had 3 years to complete your investigation.
Right, I did, yeah.
No further questions.
Any redirect?
Yes, Your Honor. May I inquire?
Yes.
Mr. Pride, you were just asked a lot of questions regarding what could have possibly happened. What does Ms. Baja state happened to Mr. Donaldson?
I'm sorry, could you repeat that? You broke up just a little bit.
Can you hear me now?
Yeah, I can hear you.
You were just in cross, you were just asked a lot of hypotheticals of what could have happened. What does Ms. Baja state happened to Mr. Donaldson?
She claims that he ran off to Costa Rica to be with another woman.
Did you look into that investigation?
I certainly did.
What was your conclusion?
That once we sent an investigator down, there was no trace of Mr. Donaldson in Costa Rica.
And when you looked into this, did you look over any documents?
I did. I looked at his bank records.
Your Honor, may I approach the witness with an exhibit?
You may.
Calling court and counsel's attention to has been previously date stamped as Exhibit 015 for identification. Mr. Pride, do you recognize this exhibit?
I do.
How do you recognize this exhibit?
These are the bank records that I looked at.
And are these bank records in the same or substantially the same condition as the last time you saw them?
Yes.
Your Honor, we now offer into evidence what has been previously date stamped as Exhibit 015 as Plaintiff Exhibit 4.
Any objection?
No, Your Honor.
Plaintiff's Exhibit 4 will be accepted into evidence and you may publish.
Apologize for that, Your Honor. Mr. Pride, reviewing these bank accounts, what did you take into consideration?
Well, so the fact that there weren't transactions after a certain time that he had allegedly disappeared, and the fact that there was still $100,000 in his account. Look, I spent a lot of times in economic crimes. People don't just leave $100,000 in an account if they're just going to fly off to Costa Rica.
And Mr. Pride, what did Ms. Baja receive after Mr. Donaldson mysteriously disappeared?
She received, according to that will and testament that she provided, everything, $10 million.
All right. Want to confer, Your Honor?
Yes, sir.
Now, Your Honor, just to clarify, with the restraining order, we offer that into evidence as well. I think during the whole argument, we didn't offer that into evidence. So we'd like to offer the restraining order with the stipulations as Defense Exhibit 5 or Plaintiff Exhibit 5.
That's fine. Is that okay with the defense?
With the understanding that the statements within the TRO are removed.
I think they're there. So that is accepted into evidence as well. And again, you may publish.
Very well, Your Honor. With that, we have no further questions and this witness may be excused, Your Honor.
From the defense, may you be excused?
Yes, Your Honor.
Does the plaintiff have any additional witnesses?
Your Honor, at this time, we would like to call the court's attention to the stipulations in the case file, specifically stipulation number 4. Is everyone there?
And if you would like to proceed by reading that, we can have it constructively read into the record, or feel free to present that in any way you'd like.
Oh, Your Honor, we can just have it constructively, stipulation number 4 constructively read into the record. And at this time, we would like to read in the last paragraph of Exotic Bob's transcript.
Go ahead.
Yes, Your Honor. So it says, now at the end of that meeting, Karen Baja walking out of my office, she stopped suddenly and turned around, and she came marching back to my desk. And she leaned over and she looked at me right in the eye and she said, Exotic Bob, because that's me, Exotic Bob. She said, Exotic Bob, I swear if you double cross me on this deal, I will do to you exactly as I did to my husband. She said, there won't be no disappearance, no mythical flight to Costa Rica. She goes, your last supper will be you. I'll feed you to my kitties just like I did him. Then she turned around and she walked out of my office. And that's all I have to say about that.
Your Honor, at this time, I'm just going to renew my objection on, that we presented during motions.
And that objection again will be overruled, given the reasons stated in motion to eliminate. That piece of evidence obviously will be read and accepted into the record. Does the plaintiff have any additional witnesses or statements they'd like to read from that transcript?
Your Honor, not. Oh, I apologize. Go ahead, Jasmine.
I was just going to say, Your Honor, not from this transcript, but my co-counsel does have something to read to you.
Go ahead.
Your Honor, assuming we're at the bench, we'd like to call court and counsel's attention to paragraph 16 of the complaint, giving co-counsel time to get there. It's paragraph 16 of the complaint. The paragraph alleges, Your Honor, on August 18, 2017, defendant filed a motion to have the probate court of Statesville to declare victim to be deceased. The probate court of Statesville granted defendant's motion to declare victim as being deceased. Your Honor, the defendant has admitted to this allegation. We ask that you instruct this jury that these facts are admitted by the defendant and therefore no additional proof is required.
Objection, Your Honor.
Please state your objection.
Pursuant to the local rules, this jurisdiction is bound by the federal rules of evidence and the federal rules of civil procedure. The argument just proffered by opposing counsel is an estoppel argument, which is a creature of foreign state law and has no bearing on this jurisdiction. Furthermore, the standards in probate court on declaring someone dead for legal purposes are not the same as proving someone is dead by preponderance of the evidence, and thus will be unfairly prejudicial against Ms. Baggio.
Am I to understand that Ms. Baggio plans on testifying in this case?
Yes, Your Honor.
At this point, I will not admit this wholehandedly, but I will allow you to question Ms. Baggio about this particular paragraph when she put in the complaint with the court when she declared the victim dead. So that's fair game on cross-examination, but I will not admit it as part of the plaintiff's case right now.
Yes, Your Honor.
Does the plaintiff have any additional evidence they'd like to present? I'm sorry, you broke up a little bit there.
I think
No,
so. Oh, okay. You're right. Got it.
The plaintiff for us, Your Honor. We have no more witnesses or motions to be heard.
Thank you. I think at this time we will take a brief recess, and when we come back, we'll take up any halftime motions and the defense can start presenting their case. Anyone have anything we need to take up before we leave? I'm thinking we break for, is 15, 20 minutes okay?
15 minutes is good. That's fine with Mr. Hunt. Also, can we request a time check during the break?
Sure. Why don't you guys work on that during the break? When we come back, we'll have an answer to how much time each party has remaining. Let's reconvene at 9:55 Mountain Time, and then we can get started if we have everyone by 10. Does that work?
Yes, Your Honor.
Yes, Your Honor.
Okay. Thank you, guys.
Thank you.
I see that all the attorneys are present. Do we have all the witnesses? And then let me clarify that we have our 2 scoring judges as well.
All the defense witnesses are present, Your Honor.
And Colette and Scott, are you guys back from your break?
Here.
Yes, Your Honor. I am.
I think I heard both people there, and it sounds like we have all of our witnesses. From the plaintiffs, are we ready to proceed?
Yes, Your Honor.
From the defense?
Yes, Your Honor.
Are there any motions either side would ask me to take up at this point in time?
Your Honor, from the defense, we do have a mid-trial motion. Permission to proceed?
Please.
Your Honor, pursuant to Rule 50A of the Federal Rules of Civil Procedure, we move for a directed verdict. Even viewing the evidence in the light most favorable to the plaintiff, they have failed to make a prima facie case for wrongful death. First, the plaintiff has failed to show that Lou Donaldson is in fact dead. They haven't brought us a death certificate, an autopsy report, a body, or any forensic evidence showing Mr. Donaldson is in fact dead. Second, they have failed to show that Karen Bashia caused his death. Plaintiff has not shown that Ms. Bashia had anything to do with this alleged death. The plaintiff herself could not testify to any observations on the night of her father's disappearance, nor did their private investigator bring any inculpatory evidence against Ms. Bashia after a 3-year investigation. On these grounds, we move for a directed verdict.
Your Honor, may I respond?
Yes, please.
Your Honor, we respectfully request that you deny the defense's motion. Your Honor, when viewing the evidence in light most favorable to the non-moving party, in this case, us, the plaintiff, a reasonable jury could conclude that we have put forth sufficient evidence to sustain our cause of actions. Your Honor, in response to both Mr. Donaldson being dead or that Ms. Bashia was the sole cause of this, Your Honor, we have provided sufficient evidence for this jury. We have shown how there was a restraining order from Mr. Donaldson towards Karen Bashia, and how 2 days after that, they're expected to believe that he gave everything away to her. Further than that, Your Honor, we've also brought and read to the jury the statements from Joe Exotic stating that Karen Bashia threatened him the same way that she threatened her husband. And she said that there'd be no mythical flight to Costa Rica. She stated, and I quote, that there won't be no disappearance. I will do to you exactly as I did to my husband. Your Honor, this is something that the jury heard, and this is sufficient evidence that a reasonable jury could intake and find for our causes. Therefore, we ask that you respectfully request the defense's mid-trial motion.
Mr. Hobbs, last word.
We stand by our motion, Your Honor.
Good arguments on both sides, and much to everyone's surprise, I'm going to deny the Rule 50 motion. And defense at this time, are you ready to proceed with your case?
Yes, Your Honor. The defense calls Ms. Karen Bashia to the stand. Permission to proceed, Your Honor?
Yes, you may.
Good morning. Please introduce yourself to the jury.
Good morning. My name is Karen Bashia.
Ms. Bashia, I want to know a bit about your work. Tell us what you do for a living.
I run the Wild Wildlife Big Cat Emporium.
What is that exactly?
It's a sanctuary for all kinds of big cats, like lions and tigers and cougars. We raise and protect these big cats from bad people that just want to exploit them, and we give them the best life we possibly can.
How did you come to get involved in this type of work?
My husband, Lou Donaldson, he got me started there. He loved big cats, and he introduced me to the work, and soon it became my biggest passion.
Let's talk a bit about your husband. How did you two meet?
Well, I was hitchhiking along a road in Statesville, and it was getting pretty late, and I was getting pretty scared, and then Lou came and picked me up.
Tell us more about your relationship after that.
Well, after we spent that first night together, we grew very close, and we eventually founded the Emporium and eventually got married, and we were happily married for many years.
I want to know a little bit more about Lou. What was he like?
Well, we loved each other very much, and I loved him for introducing me to my passion. But like anyone, he had his quirks.
What were those quirks?
Well, he had his secrets.
What do you mean by that?
Well, for one example, he would often take these unannounced flights and he would just get up and leave in one of his planes. He wouldn't tell me where he was going, wouldn't tell me when he was coming back.
You said he would leave in one of his planes. Was he a pilot?
Yes, he was.
How much did you know about his flying?
Honestly, not very much. I never knew how many planes he had, didn't know where he kept them, anything like that.
Besides the secrets, how's life with Lou?
I mean, like any marriage, we had our challenges. As much as I loved Lou and he loved me, his family never really cared for me that much. And that really put a strain on us at times. And we had a particularly rough patch in June of 2012.
What happened in June of 2012?
Lou tried to get a restraining order against me, but the court denied it.
Ms. Baja, did you ever threaten Lou before he attempted to get this restraining order?
No, I did not.
How was your relationship with Lou after that?
Well, Lou eventually told me about a mistress that he had in Costa Rica. And he told me that he wanted a divorce, but I really thought that we could work through it.
Ms. Baja, I want to talk about August 18th, 2012. Tell us what you were doing that early morning.
Well, for the most part, I was at the Emporium. A little bit before 3 a.m., I realized that I needed to go to the store to pick up some milk because there was a new baby cub at the Emporium. So I decided to make a quick trip to the store around then.
Tell us why you had to go then and there to get this cat formula.
Well, these baby cubs are always very, very hungry and they need to be constantly fed. And I've raised so many of these cubs that I knew that I couldn't just let the little guy starve until it was convenient for me to go get his food.
What happened after you got to the store?
Well, I grabbed the formula and I was ready to go home back to the Emporium to feed the cub, but then my car broke down on the side of the street and I flagged down a car and I asked to use their phone so I could call my brother because I knew my brother Carl Bannister would be around that night. So I called and asked him to come pick me up.
How did you know your brother would be able to pick you up?
Well, he's a deputy sheriff of Pioneer County, and I know that he was on call in the area that night. Plus, Carl's always been there for me, so I knew he would be able to come pick me up.
What happened after your brother picked you up?
He took me back to the Emporium so I could feed the kitten.
Did you see Lou at all that morning?
No, I did not.
Did you see Lou at all that day?
No, I did not.
How did you react to not seeing Lou?
Honestly, at the time, I didn't really think anything of it. He always disappeared and he'd go off somewhere, and I kind of figured this time was like any other.
Ms. Baja, when did you next see Lou again?
Unfortunately, I didn't. I never saw or heard from Lou again.
Ms. Baja, I want to address something that was brought up on the plaintiff's case. Were you in the courtroom when they read in the statement of Exotic Bob?
Yes, I was.
Did you ever make those statements to Exotic Bob?
No, I did not.
Tell us about your relationship with Exotic Bob.
I mean, it's not good at all. He exploits animals and he really just, he's an exploiting con artist, and I got his little operation shut down.
What do you mean by that?
Well, I mean, it wasn't really a zoo. It was a prison for poor big cats, and he only kept a big cat so he could sell them.
May we approach?
Yes, please.
We're objecting to the relevance of this information. It does not have a tendency to prove more likely or less likely that this defendant caused the death of her husband, which is the issue that we're here to decide on.
Mr. Hobbs, response?
Your Honor, the plaintiff just read an Exotic Bob statement. This goes directly to his credibility, which is always relevant.
I agree. The objection is overruled.
Yes, Your Honor.
Ms. Basia, what do you mean by you shut down his operation?
Well, I filed a civil suit against him and I eventually got all of his cats, and The civil suit eventually opened up a bigger investigation, which led to Exotic Bob being locked up.
Ms. Page, I want to address something else that was brought up. Were you in the courtroom when the plaintiff made the claim that about you claiming Lou's life insurance benefit?
Yes, I was.
Can you explain to us why you'd had to do that?
Well, at that point, it had been 5 years. I needed some sort of closure. Plus, I really needed some support to keep Lou's dream alive. And it was really hard running the Emporium by myself, and doing that without any money made it even more difficult. So making the claim was the only way that I could make sure that I could keep the Emporium going.
Ms. Baja, do you know what happened to Lou?
No, I do not.
Did you ever threaten to harm Lou?
No, I did not.
I'm sorry to ask, but did you kill Lou Donaldson?
Absolutely not.
No further questions, Your Honor.
Your Honor, may I inquire?
You may. Let's wait until we get Mr. Hobbs back.
Sorry.
But you can, there we go. Feel free to continue whenever you're ready.
Yes, Your Honor, thank you. Ms. Baja, I'm going to ask you a few questions about what you discussed during the direct examination. First, you met Mr. Donaldson while you were hitchhiking, correct?
Yes.
And you called him your Prince Charming.
Yes, that's correct.
Because he rescued you.
Yes, he picked me up that night.
And you eventually got married.
Yes.
And Ms. Baja, we can agree that you came from a less wealthy background than Mr. Donaldson, correct?
Yes, that's true.
But your husband, he was wealthy when you met him, right?
Yes.
Now, let's talk about your marriage. You and your husband, y'all had problems in your marriage, right?
Yes, any marriage has its problems.
Right. And your husband, he actually asked you for a divorce, right?
Yes, and I thought we were working through it.
But he also filed a restraining order against you, right?
Yes.
And he filed a restraining order on June 12th, 2012.
Yes, that's correct.
Now, let's discuss your husband's will. It's your position that your husband signed a will, right?
He did sign the will.
And he signed that will on June 14th?
Yes.
And in that will, your husband would give you all of his possessions if he disappeared, correct?
Yes.
And about 2 months after signing that will, you declared that your husband had disappeared, right?
Yes. He
Now,
disappeared.
Oh, I'm sorry, I didn't mean to cut you off.
No, that's okay.
Okay, sorry about that. Now let's talk about what occurred, after you said your husband disappeared. On the morning of August 18, 2012, what were you doing? I mean, I'm sorry, on the morning of August 12, 2018, on the morning of August 18, 2012, you were going to the store.
Yes, that's correct.
You had to pick up some milk for your cubs.
Yes, that's correct.
And this was around 3 o'clock, right?
Yes.
And on the way back from the store, your car actually broke down.
Yes.
So you called your brother to help you.
Yes, that's correct.
Your brother, he's a sheriff's deputy.
Yes.
He actually is a sheriff's deputy at the department that is investigating your husband's disappearance.
Yes.
And so you arrived back after your brother picked you up from your car being broke down.
Yes, I went back to the Emporium to feed the cub.
Now, later on that day, you reported that your husband had disappeared.
Yes, I did not see him that day.
And the very next morning, August 19, 2012, you went to Wild Wildlife.
Yes.
And you've been sitting in this courtroom for the entirety of this trial.
Yes.
So you had an opportunity to hear all the other testimony before you.
Yes.
And that included Cam Donaldson's testimony.
Yes, that's correct.
So we can agree that she saw you at Wild Wildlife with the police, her being with the police on the 19th, correct?
That's what she says, yes.
Now, on August 18, 2017, you had your husband declared legally dead, correct?
Yes.
And this was 5 years to the day that you reported him missing.
Yes.
And the day after that, you were able to inherit your husband's insurance policy, correct?
Yes, I was the beneficiary and I needed the money to keep the Emporium going.
And maybe you didn't understand my question. I asked you if the day after you declared your husband dead, you were able to inherit his insurance policy. And the answer to that is yes, right?
Yes.
And that insurance policy was worth $5 million.
Yes.
And you also took over your husband's business, correct?
Yes, we co-founded the business together. We ran it together.
And immediately after taking over your husband's business on the 20th of August, you fired his daughter, correct?
Yes.
Your Honor, a moment to confirm.
Yes, please.
Your Honor, no further questions.
Thank you. Any redirect?
No, Your Honor.
May this witness be excused by both sides?
Yes, from the defense.
Yes, Your Honor, from the plaintiff's side.
I suppose you're just going back to your counsel table. But at this point, does the defense have any additional witnesses they'd like to call?
Yes, Your Honor. The defense calls Chris Renard to the stand. Permission to proceed.
When you're ready.
Good afternoon. Please introduce yourself to the jury.
Good morning. My name is Chris Renard.
Let's talk about your education. Where'd you go to school?
I received my Bachelor of Arts in Criminology from Summit College.
Where is it that you work now?
I work for Summit Life Insurance.
How long have you worked for Summit Life Insurance?
I've been working there since 2000.
What exactly is it you do for Summit Life Insurance?
I work as an insurance investigator and as a forensic document examiner.
In your own words, what does this mean?
Well, usually they'll assign me to look into a death or a disappearance, and then I gather information and I to figure out what happened. It's kind of like being a private investigator.
Now, what was your role in this case here today?
I had to conduct an investigation on behalf of Summit Life Insurance to figure out whether there's any suspicious circumstances in Mr. Donaldson's case and look at a signature composition for the will of Mr. Donaldson.
Now, to be clear, were you hired by one of the parties in this room to investigate the facts of this case?
No, I was hired by my employer, Summit Life Insurance.
Can you now tell us why it is you're hired to conduct these investigations that you mentioned?
Yes, well, someone's declared dead in this and there's a rather large payout given to a beneficiary. They need to hire somebody to investigate the circumstances to make sure there's no foul play. Make sure that indeed that there is an obligation by the employer, Summit Life Insurance, to pay out that policy. It's generally standard in this type of claim, especially of this magnitude.
Okay, Mr. Renard, you mentioned foul play. What do you mean by that?
I just mean my job is to determine whether there's any extraordinary circumstances or anything suspicious within the document itself that would indicate that the policy should not be paid out, or whether there would be anything to deal with Miss Basia, with whether Miss Basia had anything to do with Lou Donaldson's disappearance.
How many years of experience do you have investigating insurance claims?
I've been working there for 20 years doing insurance.
I'm sorry, Mr. Renard, I apologize. How many years of experience do you have as a forensic document examiner?
I've been doing that for about 23 years.
So you mentioned for the jury that you conducted an investigation and a signature comparison. Let's talk about your investigation first. Tell us how you conduct an investigation.
Objection, Your Honor. May we approach?
You may.
Your Honor, at this time, we'd like to renew our motion in limine that this individual is going to be used as a fact witness and be used as a conduit for what would otherwise be inadmissible hearsay. If this witness testifies in accordance to your deposition, we anticipate that the following questions are going to elicit hearsay from the police department and different investigators on investigations that this individual hasn't done.
Mr. Nunez, any response?
Your Honor, no hearsay statements will be elicited.
At this point, I think the objection is a bit premature. I think the defense is still laying foundation for this witness to potentially be an expert, discuss their investigation. Obviously, expert witnesses can rely on certain pieces of hearsay to come to their conclusions, but I think it's a bit premature to get into the objections to specific lines of questioning or answers. So at this point, I will overrule.
All right, Mr. Renard, can you tell us how you conduct an investigation?
Yes, in general, I'll compile a set of facts that surrounds the whereabouts, and in this case, it'd be of Lou Donaldson.
What facts did you compile?
Well, first, that Mr. Donaldson was last seen on August 17th, 2012, and was legally declared dead on August 18th, 2017.
With this information in hand, what did you do next?
Well, I had to determine where Mr. Donaldson could be or was, so I contacted the sheriff's department and spoke with multiple friends, family, and associates of Lou Donaldson.
Now, Mr. Renard, without telling us what these parties said, after you spoke to them, what did you do?
Well, based on those conversations with the police department and his associates, I told Summit Life Insurance that Karen Bass's claim was valid, and I did not find sufficient evidence for Karen Basia to have linked to his death or disappearance.
Now I want to talk to you about the documents you examined. What does it mean to be a forensic document examiner?
It simply means I examine the documents and then I determine whether there's a forgery or not.
How does one go about doing that?
Well, in this case, you have to obtain the documents in question, and this one being the will.
What certifications, if any, have you received in this field?
I've been certified by the Board of Forensic Document Examiners and the Association of Certified Fraud Specialists.
How about trainings?
I actively participate in training workshops, and I continuously take part in continuing education related to forensic document examinations.
Without telling us your opinion just yet, did you come to a conclusion in this case?
Yes.
What did you rely on in coming to your conclusion?
I relied on the evidence provided by both parties, including the will and multiple other signatures.
Now, are these the types of facts and data that other experts in your field would rely on?
Yes.
When reviewing these documents, did you apply a series of reliable methods that other experts in your field would use?
Yes, I did.
Now, did you reach your conclusion to a reasonable degree of professional certainty?
Yes, I did.
Your Honor, pursuant to the witness's testimony and Federal Rules of Evidence 702, I offer this witness as an expert in forensic document examination.
Any objection or voir dire?
No objection, Your Honor.
The witness shall be so tendered as an investigator and someone who is an expert at document and forensic investigations.
Now, Mr. Renard, once you had the documents in question, what did you do next?
Well, I needed to compare the signature that was on the will with the other known signatures of Mr. Lou Donaldson.
Did you have other known signatures?
Yes, I obtained two other known signatures. One was from his driver's license, and another was from paperwork that Mr. Donaldson signed originally with Summit Life Insurance.
Now, with all these signatures, what did you do next?
Well, first I had to review the original signature on the will and then compare it with the other ones.
Your Honor, at this time, I believe page 40 of the record has already been admitted as one of plaintiff's exhibits. We just wish to publish that with redactions at the bottom.
Any objections?
No objection, Your Honor.
Feel free to publish.
All right, just one moment. All right, Mr. Renard, can you see that?
Yes, I can.
Opposing counsel, can you see that?
Yes, I can.
All right. When comparing the signatures, what did you see?
Well, as you can see, there are similarities and some differences, but in general, my findings were inconclusive at best.
What do you mean by inconclusive?
Well, that it was possible, but very unlikely that someone tried to copy Mr. Donaldson's signature.
What are the similarities you see in these signatures, if any?
Well, you can see there's similarities in the loops and the stroke, the direction, the curves, the legibility, the angles, and the embellishment and its capitalization. As you can see here, the same loop is used twice between signature 2 and the question signature.
What are the differences in the signature that you see, if there are any?
Well, in general, you can see that the signatures themselves are not exactly the same.
What are some reasons that signatures might not be exactly the same?
Well, in general, there are many reasons why signatures can vary from one to the other. Often this has to do with either the age of the person self-signing, or the health, or even the care or the circumstances in the moment when they signed it. A writing instrument, or it could just simply be that they were in a rush or wanted to sign it a little bit differently.
Now, if a signature is different due to these reasons that you just mentioned, what might you see present in a signature?
Often you could see some sort of either tremors or maybe a bit of shakiness or just overall carelessness that kind of indicate those.
How did this knowledge impact your conclusion?
Well, in general, led me to believe that they cannot verify whether the signature was forged on the will.
Can you explain to us why that is?
Well, even though there are some minute differences in the signatures, Mr. Donaldson could have just gotten a bit careless or sloppy with his advanced age. And I don't really see a cause or concern. And I see just as much similarities as I do differences.
Hold on.
What's your objection?
Your Honor, in regard to part of the answer of whether Mr. Donaldson could have gotten sloppy or careless, they stated that these could be causes, but there is no evidence or foundation laid of whether this is what actually happened to Mr. Donaldson, and this has the danger of misleading the jury into believing that this is what actually happened and why there were some differences where there was no foundation laid in that.
Any response?
Yes, Your Honor. This witness is an expert in handwriting analysis. He's simply explaining the possibilities that could happen with regards to the signatures on the will. This is going to our theme in this case.
Last word, Mr. Tuso.
Just once again, Your Honor, what this expert, they have been tendered as an expert. This jury hears an individual who has the label of an expert state that he could have been careless, that he wasn't paying attention, that there were tremors without the actual foundation or with actual scientific proof of this, then this is going to mislead the jury and is going to, because this is coming from an expert, and they'll believe that this is what in fact happened. Therefore, Your Honor, we ask that you strike this response from the record.
I'll allow the expert witness to opine as to what he thinks happened. So the objection is overruled. Obviously, this is good fodder for cross-examination. You may continue.
All right, Mr. Renard, I'm going to ask you that question once again. You mentioned that you could not say whether the signature of the will was forged. Why is that?
Well, in general, I could not say it was forged because the differences between them were not enough to really be significant in my mind that they couldn't be just explained away by other characteristics potentially within the signature itself, the signer themselves.
What were the results of your analysis of these signatures that you provided to Summit Life Insurance?
Well, I found that there was not enough evidence to show that the signature itself was a forgery, and that I recommended to Summit Life Insurance that they pay out the $5 million, and that the will itself was not forged.
Thank you. No further questions at this time, Your Honor.
Cross-examination.
Good afternoon, Mr. Renard. I know that I've been having some technical difficulties. Can you hear me fine?
I can hear you fine.
Very well. Mr. Renard, I want to talk about your ultimate opinion of that you spoke about during your direct. You said that your final determination was that your company should pay out $5 million to the defendant, right?
Yes.
And by doing so, you and your company, well, you were able to avoid any possible future costly litigations, right?
That's one way to put it, yes.
Well, that's how you put it, Mr. Renard.
Well, I recommended that they pay out the policy because, again, I could not find any reason to show the signature itself was a forgery.
But just to be clear, Mr. Renard, your words were, we were able to avoid future costly litigation, right?
Yes.
Now, let's keep talking about this $5 million payout. Mr. Donaldson was declared missing on August 17, 2012,
Correct. Yes.
but he wasn't legally declared dead until August 18, 2017, right?
Yes.
And August 18, 2017, that's when the defendant asked for payout that very same day, right?
I believe it was the day after, actually.
But we can both agree that that raised some concern.
In general, any case with this larger payout does raise concern. There's always a proper examination done.
So Renard, let's move on and talk about your analysis on the will. You had the opportunity to look over the language of the will, right?
Yes.
And you have investigated hundreds of wills during your time.
Yes.
And when you reviewed the language on this will, well, you saw language that you had never seen before, right?
There's always a bit of intricacies, but I did see some language I hadn't seen often.
And that language was, if I should die or disappear, right?
That is the language you're talking about, yes.
And there are some signatures on this will besides Mr. Donaldson's signature, right?
Yes, 2 witnesses.
Let's talk about those witnesses. When you looked at, one of those witnesses is Samantha Lane, yes?
Yes.
And Ms. Samantha Lane, you were able to speak with her.
I received a letter from her, yes.
But, very well. And in this letter that you received, at the bottom of that letter, there was a signature on it. Yes?
Yes.
And that signature read Samantha Lane.
Yes.
And the contents of that letter, one part said, I never saw Mr. Donaldson sign, right?
Yes.
And another part said, I was coerced in signing the will.
Yes.
Now, Mr. Renard, you were also able to look into Mr. Donaldson's own signature, right?
Yes.
Those were the samples that you put on the screen and that we were able to look at.
Yes.
And when you compared just the 2 samples, the ones that you had obtained beforehand, you stated on your report that those samples matched.
Yeah, I saw enough significant similarities to conclude that there was not a forgery.
Oh, I apologize, Mr. Renard. Maybe I didn't make myself clear. I'm just talking about the samples right now, not the alleged signature, just the samples that you looked over. When you compared those 2, you said that those matched.
Yes.
But it wasn't until you matched those 2 samples with the alleged signature on the will that you ever mentioned that there was a difference, right?
No, not necessarily.
Mr. Renard, you didn't mention that there were any differences until you compared the alleged signature with the 2 samples.
I believe I stated in general, signature to signature, that's never going to be exactly the same. There's always some differences between.
But we can agree that there were differences between the samples and Mr. Donaldson's alleged signature.
Yes, and similarities, like I stated before.
Right. Looking at the other witness, Mr. Renard, the other witness on this will was Ms. Bazia, right?
Yes.
And when she signed this, she was, when she signed this, she was the beneficiary.
Yes.
And she's the defendant in today's case?
Yes.
And just to clarify, you'd agree with me, Mr. Renard, the beneficiary, that means someone that's going to benefit off of a will, right?
Yes.
And to be clear, she wasn't just a beneficiary of this will, she was the sole beneficiary, right?
Yes.
Moment to confer, Your Honor?
Yes, Your Honor.
No further questions, Your Honor.
Any redirect?
No redirect, Your Honor.
May this witness be excused by both sides.
Yes, Your Honor.
Thank you.
Does the defense have any additional evidence that they would like the court to consider?
We do not, Your Honor. The defense, hold on. Moment to confer with counsel.
Sure.
We just renew our mid-trial motion at this point.
And that will be denied once again. At this point, we have closing arguments. Do we need a brief break before closing arguments, or are the parties ready to proceed?
Your Honor, could we get a brief break as well as a time check?
Sure. Why don't we figure out the time over the break? Is 5 minutes okay?
5 minutes is perfect.
We'll reconvene at 10:35 Mountain Time, and we'll figure out the time when we get back.
Yes, Your Honor.
Do we have everyone back and ready for closing arguments?
So, I think everyone is back, Your Honor.
Let me just verify really quickly that the other scoring judges are all back.
Yes, Your Honor.
I'm here.
Okay. I think we're ready to go. Before we begin, any issues either side needs to take up before the plaintiff's closing argument?
Yes, Your Honor. Your Honor, from the plaintiff side, two things. We wanted to let you all know that we will be using the restraining order in our PowerPoint during closing, but we wanted to indicate that it was constructively, the things that were removed, the words within it have been constructively removed. And we wanted to reserve 2 minutes for rebuttal.
It looks like you guys have a lot of time left, so I think easily you'll have 2 minutes left for rebuttal. And then obviously publish whatever exhibits you like. The jurors will be instructed with whatever redactions have been made before obviously they make their decisions in this case.
And that's all of our matters, Your Honor.
Any issues from the defense before we begin?
No issues, Your Honor.
Okay, closing arguments from the plaintiff.
May it please the court, counsel, members of the jury. At the beginning of this trial, we told you that in the jungle, there are rules, and those rules have to be followed in order to survive. And no one was more aware of those rules, or I should say, her interpretation of them, than the defendant. A woman who has spent most of her life working with some of the jungle's most dangerous animals. The number one rule for her, self-preservation. And when the privileged lifestyle that she enjoyed was in danger of being taken away from her, nothing was going to stand in her way. Not a will, not a family, not a daughter. Nothing was going to stand in the way of her preserving her way of life. She was cold, she was calculated, she was conniving, and she looked out for one person and one person alone, herself. Now, we made some promises to you at the beginning of this trial, and I want to make sure that you know we have honored those promises. We have fulfilled our responsibility here today. And in a few moments, the judge is going to read you the jury instructions that will contain the elements of this case. And we have proven all 4 of these elements. The first thing that we proved to you today is that Mr. Donaldson is no longer with us. And we brought you evidence to show you that. But no evidence was more telling than the fact that the defendant, she sat here in front of you all today, and she told you that she raced down to the courthouse to have her husband declared dead so that she could recover his money. 5 years to the day that she said that he went missing. She knew he was dead because she did it. And on top of that, we also bought you Mr. Donaldson's bank statement. This statement right here. And on that statement, you saw that the last transaction Mr. Donaldson ever made was on August 17, 2012. The last day that his daughter ever saw him, the last day that he was ever alive. And in the span of 1 week, Mr. Donaldson withdrew $100 on the 6th, $100 on the 10th, and $140 on the 15th, coming to a whopping total of $340. Now, the defense, they have floated around this idea that a man with almost $100,000 in his bank account left everything behind, everything, with only $340 in his pocket. In the 5 years that he was allegedly missing, that amounts to only less than 19 cents a day. Not even enough money to purchase a bottle of water. And the defense, they want you to believe that Mr. Donaldson went to Costa Rica, that he just left. He left without telling his daughter, who had access to his bank accounts, his will, everything. He left without telling her anything, the person that he trusted the most. Think about that. And the second thing that we proved to you all today is that the defendant caused Mr. Donaldson's death. And we brought evidence before you to show you just how toxic things were in the Donaldson household. But you wouldn't know that from listening to the testimony of the defendant. She said that they were in love. But the evidence that you saw today with your own eyes, it painted a completely different picture of their relationship. It wasn't a fairy tale, not a fairy tale at all. It was a nightmare, ladies and gentlemen. Mr. Donaldson, he wanted a divorce from his wife. He was terrified of her. He even filed a restraining order against her. And you saw that restraining order today. And you were able to hear Mr. Donaldson's own words. If anything ever happens to me, Karen is responsible. Look at Karen. And that restraining order, the mention of a divorce, that set the defendant off. She was living a privileged life off of her husband and his money. And she had to act fast to make sure that she could preserve that. And guess what? She entered into survival mode. She forged a will that cut out Mr. Donaldson's family and left all of his possessions to her. A will that left an estate valued at $10 million to her. And they want you to believe that he did this only 2 days after filing a restraining order against her. Talk about a change of heart. But today, we didn't just bring you evidence of the defendant's suspicious actions. No, we brought before you an expert in document examination, Taylor Pride. And Taylor Pride testified that the defendant's will, that signature on it, it was forged. It was fake. And his examination was based off of other known signatures of Mr. Donaldson. And not only did Mr. Pride come before you, you also heard from the defense's expert witness, Mr. Renard. And both witnesses, in their 20 years of experience, said that they had never seen the language on the defendant's will in a will before. And you also heard the statements of a witness to that will. A witness who said that the will was forged, admitted this against her own self-interest. But the defendant, she couldn't just stop at a forged will. No, she had to make her husband disappear, just like that forged will said. And how did she do that? Well, you know exactly how she did that because she told Exotic Bob. She told him that she would do to him exactly what she did to her husband, that she would feed him to her cats. And those are not my words. Those are the words of the defendant. The third thing that we proved to you all today is that the defendant caused my clients severe stress and emotional disdain. The defendant broke into Wild Wild Life one day after she declared that her husband was missing. And she stole a lockbox out of my client's locked drawer. And inside of that lockbox, it was Mr. Donaldson's actual will. And the defendant, she tried to play this off. She said, it wasn't a big deal. She owned Wild Wild Life. But members of the jury, you all saw the broken lock. And you saw the hole in the back gate. Does that look like the behavior of someone who had nothing to hide? Someone who was doing what they were supposed to be doing? No, it doesn't. Members of the jury, this defendant was doing what she needed to do to get what she wanted. And she didn't care who was in the way, she would get rid of him. Like my client, who she fired immediately after taking over Wild Wild Life. Like Samantha Lane, who has mysteriously disappeared since coming clean about the forged will. And like Mr. Donaldson, who was afraid for his life and trying to leave her. Now, the fourth and final thing that we have proved to you all today is that it was the defendant's actions that caused my clients damages and injuries. The defendant had the means, the motive, and the opportunity to cause Mr. Donaldson's death. And she did just that. Now, this is not the jungle. And the defendants, her rules, they do not apply here today in this courtroom. proved all of the elements of this case. We've checked off each and every one of these boxes. And now it's time for me to talk to you all about damages. In our system, you, to the extent possible, have the power to right this wrong. And how do you do that? Well, in my mind, if you could, you'd wave a magic wand and you put everything back the way that it was supposed to be. Mr. Donaldson would be alive and he'd be back running his business with his daughter. But you don't have a magic wand and you can't bring Mr. Donaldson back. In our system, we restore, we even the score with money. And as inadequate as that may be, that's all that you have. But in that respect, your power, it's unlimited. And in order to help you evaluate the loss, I want to talk to you all about what my client had. She had a father, a friend, a trusted companion. She had her dad. Her loss was and is profound, and it will always be with her. And because of that, we are asking that you rightfully award our client with $10 million, which is the value of the estate that the defendant stole. We ask that you award our client with $1 million for the suffering that she endured after being terminated wrongfully from her job of over 20 years that she worked at with her father every day. And we ask that you award our client with $2.5 million for the pain and suffering that she will go on to endure for the rest of her life because of the loss of her father, caused by the defendant's actions. This is justice, and anything less is just not. You can't bring Mr. Donaldson back, but what you can do, you should. And what you should do, you must. You should use the evidence that you saw here today, the testimony that you heard, and most importantly, your own common sense to come to the only conclusion in this case that is supported by the facts. When you go into that back room and you're given this verdict form, you should find the defendant, Karen Baja, liable for the wrongful death of Mr. Donaldson. And you should hold her responsible for $13.5 million in damages. You should find her liable because she is.
Thank you, counsel. Closing arguments from the defense.
Yes, Your Honor. One moment to change cameras. Oh, just give me 1 second, Your Honor. I'm having a technical difficulty here. Your Honor, do you mind if I leave and come back?
Take your time.
Sorry. My apologies to the court. Permission to proceed.
When you're ready.
I want to make this very clear. No body, no proof, no liability. The burden of proof rests. It rests with the plaintiff, and it's called a burden for a reason. Because when a plaintiff drags a citizen of our state into court and alleges that they caused someone's death, it is their job to meet that burden. Today, the plaintiff had to prove to you that it is more likely than not that Lou Donaldson is dead, and that he is dead because of a wrongful act caused by Karen Baja. They failed. They had to prove that their theory was the most likely outcome, and they did not do that. And they failed from the very beginning, members of the jury. The plaintiff has failed to prove to you that Lou Donaldson is actually dead. In fact, based on what they brought you here today, we have no idea where Lou Donaldson is. He could have just disappeared. Ms. Baja's not a killer because she asked the court to have Lou Donaldson declared dead after 5 long years. Having someone declared dead is so different than actually being dead. There's no body, no death certificate, no autopsy report, no tombstone in the ground. Had the plaintiff had any single one of those things, they would have been waving it in front of your face this entire trial. Think about it. Lou Donaldson, he had the means to leave and disappear at any moment. He left his family once before with no problem when he met Miss Baja. In fact, the plaintiff had to take the stand and admit that Lou Donaldson would fly under the radar so no one could track his movements. And speaking of means, Lou Donaldson, he had money, the kind of money that someone could use to disappear and never be found. For all we know, actually, we do know Mr. Donaldson had multiple bank accounts, as the plaintiff admitted that she did not have access to all his accounts, which means it's likely that Lou Donaldson probably had a secret stash that only he had access to. And let's be honest, Lou Donaldson, with all his secrets, he was a money under the mattress kind of guy, and the plaintiff failed to show you otherwise. The plaintiff, they brought you Taylor Pride to try and help prove Lou Donaldson's death. But members of the jury, I know you all remember my co-counsel's cross-examination. After 3 long years of investigation, what would you expect to see? And I wrote it down because it's important. You would expect to see security footage from the airstrips where Lou Donaldson was last found. You would expect to see a death certificate, reports of visits to the morgues and hospitals, interviews with family, friends, employees, or anybody at the airstrip. How about, at the very least, an attempt to trace Lou Donaldson's steps on the night he vanished? Plaintiff's expert didn't bring you any of that. And that right there, members of the jury, that is unacceptable. He admitted, had he done these things, it could have affected his opinion. Not to mention, that expert was giggling on the stand, smiling about what he didn't provide you here today. Plaintiff's expert is either an awful investigator and forgot to do these very simple steps, or he did do them, and the results just did not favor his client. Either way, the plaintiff, they have failed to meet their burden. Now, the plaintiff who paid Taylor Pride, Karen Baja, hates Karen Baja. She hopes that she would get eaten by one of her tigers. But today on the stand, she wanted to retract that statement because of how bad it sounds. Not to mention on direct examination, Cam Donaldson had all the answers. She, in her own words, was the person who made Wild Wildlife run. But when I asked her a few simple questions on cross-examination, members of the jury, she suddenly had memory loss. You must examine the credibility of this witness. She knew her answers to my question would show that she was bringing this case for the money. Because she claimed she had no knowledge to my simple question. She was trying to secure her bag. She's here for the money. Yet, despite all of that, this plaintiff still could not provide you with proof that Karen Baja killed Lou Donaldson. And that's because none exists. And that is exactly why the plaintiff has failed to prove that Lou Donaldson is dead. Let's entertain the thought. Let's just entertain the thought that Lou Donaldson is actually dead. Even if you believe that, the plaintiff's case still fails. They couldn't bring you one piece of evidence connecting Miss Baja to Lou Donaldson's disappearance. What the plaintiff brought you was a temporary restraining order that proves nothing and was ultimately denied. All this evidence shows you is that Lou Donaldson, he was an unpredictable man. It makes sense. It makes sense. He was the type of man that would file for a temporary restraining order one day and just a few days later make that person the sole beneficiary of his estate. And yes, like husband and wife, Karen Baja and Lou Donaldson got into arguments. And yes, he asked for a divorce. And yes, he filed for this TRO, but he filed for this TRO and he asked for that divorce in the heat of the moment. And we know it wasn't serious because plaintiff had to concede that Mr. Donaldson, as far as she knew, went home to his wife every night after that TRO was denied. If Lou Donaldson had actually feared his wife, what would you expect to see? You would have expected him to call the police on her, found a new place to live, gone and lived with his daughter, asked his daughter to come live with him, actually filed for a divorce the 2 months after he filed that TRO. You would have expected to see an invoice in his bank statements for a divorce attorney. But we didn't see any of that. And this supports Ms. Baja's claim and testimony that she and Mr. Donaldson were working through their issues. Next, the next thing is the plaintiff wants you to believe that Ms. Baja is a killer because of words that are written on a piece of paper. They want you to believe that Karen Baja killed her husband because of language in a will. That dire disappear language is there because Lou Donaldson clearly adapted his will to his lifestyle. Think about it. Lou Donaldson would pick up and leave with no notice, flying across miles and miles of open ocean under the radar without logging his flights with the proper authorities. He chose this wording because he trusted Miss Baja to carry out their dream, their shared purpose in life, the Emporium, just in case one of those trips ended up being his last. And you know what? Lou Donaldson, he was right in doing that because Miss Baja dedicated her life and she dedicated her soul and successfully ran that Emporium for 5 years without any financial support from the estate. Not to mention, this wording shows that Lou Donaldson was consistent. The plaintiff doesn't dispute that Karen Baja was the only named beneficiary on his life insurance policy. That means he wanted to leave Karen Baja and only Karen Baja with that $5 million. So it makes sense that he would do the same thing for his will. Now, with regards to Exotic Bob's statement, he's in prison. His statement isn't reliable. You can't trust his word. His statement was not made under oath, and he is clearly biased. The only reason he is saying anything is because he is in jail due to the fact that Karen Baja exposed his mistreatment of big cats. And you know what he wants now? He wants revenge. And the last thing that the plaintiff wants you to concentrate on is the signature analysis done by Taylor Pride. Let's look at the glaring flaw in that comparison. Taylor Pride, the expert hired by the plaintiff, had access to a handwritten note by Lou Donaldson written just 1 month before the will was signed. That handwritten note would have given Taylor Pride so much more to work with than a few random signatures. Taylor Pride didn't talk about this note. It didn't come up. And that's because the writing in that note was probably the most similar to the signature on the will. Members of the jury, don't you want to see that note before you make your decision here today? Of course you do. Also, remember, we the defense, we have no burden here. The burden, it rests and it remains with the plaintiff. However, we did bring you reliable evidence. We brought you Chris Renard, an unbiased expert with no skin in the game. You can trust his opinion because insurance companies like Summit Life Insurance, they want to make a profit. They want to pay out multi-million-dollar claims. And yet, despite all this, despite 5 million reasons not to give Ms. Baja that claim, they decided that she was entitled to receive that $5 million payout on Mr. Donaldson's life insurance policy. His investigation showed no evidence of foul play and that the validity of the will is inconclusive. You know what this means? It means that there is no evidence that Karen Baja had anything to do with Lou Donaldson's disappearance. And that right there, that is the key, members of the jury. Lou Donaldson, he just disappeared. We don't know how. We don't know why. But I want you to think about something. It's late night. Lou Donaldson is awake and he's thinking about clear blue skies in Costa Rica. He's thinking about a beautiful woman sitting next to him and a cigar in his mouth. Then the idea hits him. Life is too short. I have worked too hard not to truly live. He has the means. He has the planes. He has the cash. And in that excitement, he grabs his bag. He grabs his money from under the mattress and he goes to his van and he flies to one of his airstrips. And as he's getting to that airstrip, the sun, it's starting to peek over the horizon. And he starts to rush. He gets his stuff, gets on the plane, takes off, flies a couple 100 miles and realizes he forgot his glasses. The plane's fuel is low. The engine is sputtering. He's starting to slowly fall from the sky. Lou Donaldson is looking for a place to land, but he can't see and he crashes. That's why nobody has heard or seen Lou Donaldson in all this time. And that's why there's no body. It's somewhere in the miles and miles of ocean between Statesville and Costa Rica. The plaintiff can't show you that this isn't exactly what happened. And now, members of the jury, now it's your turn. You have the power to tell the plaintiff to prove it. So when plaintiff's counsel gets back up here, I want you to challenge her. Ask her for one piece of forensic evidence. Ask her for footage showing that Lou Donaldson never made it on the plane that morning. Ask her for a death certificate, an autopsy report. They won't be able to provide you any of that. And plaintiff's counsel said, this isn't the jungle. But you know what? This isn't the next Netflix big true crime story either. This is a court of law. We demand facts, we demand evidence, we demand proof. The plaintiff might say they have circumstantial evidence, but really, in reality, what they're asking you to do is play a game of hopscotch, and they want you to start at 1 and jump all the way to 10, skipping every box in between, and that is unacceptable, and you cannot do that. And when you realize that this is what the plaintiff is asking you to do, I am positive that with no body, no proof, you will find Karen Baja not liable. Thank you.
Thank you, counsel. Any rebuttal by the plaintiff?
Yes, Your Honor. May I inquire?
You may.
Members of the jury, the defense, they came up here and they gave you several hypothetical situations that they never discussed during the case in chief. They said maybe Mr. Donaldson is on a beach smoking a cigar with some woman. They said he might be in the ocean because his plane crashed. We don't know any of this, but what we do know are the facts. We know what the defendant said out of her own mouth. I will do to you exactly what I did to my husband. There won't be no disappearance, and there won't be no mythical flight to Costa Rica. I'm going to feed you to my kitties just like I did my husband. Those are not my words. Those are the words of the defendant. And the only thing that was unacceptable today is that this defendant thought that she was still in the jungle. But no, she's in the courtroom. And she's not going to get away with causing the death of her husband. Not today. Members of the jury, this defendant, she had the means of giant cats that eat meat. She had the motive of maintaining the wealthy lifestyle that she married into. And she had the opportunity that she created for herself when she forged that will 2 days after her husband filed a restraining order against her. She set her plan into motion and she carried that plan out. She made her husband disappear, and then she took all of his money, she took over his business, and she kicked out his daughter, the person that he trusted the most. Today, all of a sudden, she has a problem of being able to say whether or not Mr. Donaldson is dead. But she had no problem saying he was dead when she went to the court to get that $5 million insurance policy. This defendant, she caused the death of her husband. The facts are clear. We don't need to rely on hypothetical situations, crashes that never happened. We have the facts right here today in front of you. The restraining order, the divorce, the fact that she got his $10 million estate. And that's why we're asking you, members of the jury, to find this defendant liable for causing the wrongful death of Mr. Donaldson, because she did. Thank you.
All right. Thank you, guys. Virtual round of applause. Everybody did great. At this point, I want to take just a couple of minutes, pass it over to some of the scoring judges. I think there are 3 in this round. See if they have any comments or anything that they'd like to add at this point.
Hi, my name's Colette. I'm one of your scoring judges today. I just wanted to echo our judge and say that you all did a really great job. I think across the board, you all did a really wonderful job of clearly being passionate, but keeping yourselves measured and not veering too far into becoming overly argumentative. So I think you all represented yourselves really well, and you should be super proud.
Thank you.
Thank you.
Thank you.
Anybody else have any comments?
Yeah, just echoing Colette's points. I think everyone did fantastic. I guess to like differentiate a bit, I just want to say I think everyone's tone and pacing was really good. I had a good time, an easy time paying attention. That being said, over Zoom too, you guys did a great job of keeping my attention, which I really appreciated as well. So yeah, best of luck to everyone. And it was a pleasure being able to be here.
Thank you.
Thank you.
Thank you.
Thank you.
Anybody else? All right, I'm going to hop in a little bit. My name is Grant Groskebauer, and that name might sound familiar because apparently I am the custodian of records on the bank statement, which I did not know until that was published. So thank you to my friend who wrote this case, Mr. Storgard, for including me in it. A little bit about me. I went to the University of Denver, Sturm College of Law, graduated in 2016. I am a deputy district attorney in Arapahoe County, which is just a suburb outside of Denver. I've been doing that for about 4 years. When I was in law school, I competed in similar tournaments, NTC, AAJ, Top Gun, and traveled all around the country. You guys obviously aren't traveling, but this is a national tournament. So I know that you're the best of the best from your schools that are getting to compete in this. A couple of things that I want to add. Obviously, you guys are getting to experience the age of technology like we've never experienced before. Last week, actually this week and into last week, I conducted a jury trial that was one of the first to go in our state, and a lot of it was virtual. And so you guys are learning a lot of skills that otherwise we didn't know, and we've had to sort of pick up. For instance, obviously you can imagine it with COVID, the rooms have to be limited to a certain amount of people. So a lot of my jury members are in a completely different courtroom, in an overflow courtroom. We had to quickly pick up how to use technology, how to publish exhibits, how to go through jury questionnaires with people who were in different rooms. And so I think you guys are really ahead of the game when it comes to that. I'm sure you're having to experience a lot of this, and it's probably a tough time to go to law school, but you're getting to experience a lot of the technology associated with what I think the future of lawyering is going to look like. One of the other things that I'll say that you guys did a great job of is obviously through COVID, one of the things that has kept me sort of sane is that I still get to watch sports. And it's different because there aren't crowds. And so what you realize is a lot of those athletes have to create their own adrenaline and kind of hype themselves up. And that's something I saw you guys do a great job of, is that you don't have the same adrenaline you might have in a courtroom where you're facing jurors, you're facing scoring judges, you're facing each other, you're facing a hostile witness. But just in terms of hyping yourselves up, I think you guys did a great job. I want to give particular props to the plaintiffs. Obviously, you guys have the burden of proof, but the use of technology in the closing arguments, as well as throughout the trial, was very, very impressive. Also, to all of you, I think you did a great job of going with the flow on some of my rulings. Some things are maybe excluded that you didn't expect. Some things maybe came in that you didn't expect. And I'm sure that that happened throughout all of your rounds. As scoring judges and just like your judges are in real life, I don't know the facts of the case. I don't know what certain exhibits say. And so I think you guys did a good job sort of rolling with the punches there. The one tip that I'll give, and it's probably tough to do, I imagine, over Zoom or over video conferencing, is your ability to witness control. It's one of the hardest things that you learn how to do as a lawyer. But just as an example, in Mr. Nunez's cross of the plaintiff in this case, a couple of times she would sort of assert things that maybe she didn't know that I think he could have jumped on. He left a little bit of the meat on the bone there. She would say things like, that completely fraudulent will. And I think that's a good opportunity, even virtually, for you to jump in and say, wait a second, you're not an expert when it comes to handwriting. You don't know this is a fraudulent will. Your bias is showing. right? Like this is an assertion that you want to be true, but you don't have any of the requisite knowledge. I also picked up that her answers, which you used brilliantly in closing argument, is she had no knowledge of at least like 50 things, right? And I get that is her cue in a mock trial type environment to say that is not information that I have in my deposition or in my reports. And I understand that's a cue. I think you could have jumped onto that a little bit more instead of just accepting no knowledge. It's like, you know, you have no knowledge of this because you're not as in tune with the business as you seem to think, right? Like you don't have knowledge of these things, and yet you're purporting to be this person who has control over the business and all these bank accounts and all that. That said, I think you did a great job in closing argument of using that to your advantage and saying, you know, she had no knowledge of at least like 50 things. Come on. That's all I have. Do you guys have any particular questions for me? I know this is your final preliminary round. You could have rounds this afternoon, but I'm happy to answer any questions that you guys have.
No, Your Honor, nothing for me.
No, Your Honor.
No, Your Honor.
Good. Thank you.
Okay, great. I think that's all we have. I'm going to go ahead and end the live stream, and I'm going to shut down the Zoom. Everybody, good luck going forward. Great job today.
Thank you. You have a nice day.
Thank you.
Thank you guys. Bye.